Good morning, all. Is there any housekeeping to deal with before we take Mr. Gattari?
Nothing contentious, Mr. President. We've agreed on the timing. If it becomes necessary to use all of it, the claimants have 2 hours and 54, and we have 3 hours and 6 if necessary. And we've also agreed on the closing brief that it's agreed that we will have 25,000 words, which was our proposal. So I think peace has broken out on all those fronts. Right.
Thank you very much.
Then let us have Mr. Kaplan. Just to the tribunal's raised a couple of times as housekeeping the user-friendly access to exhibits. We've discussed this with Mr. Kaplan. I just want to make sure that the loop is closed. Have the panel been instructed how to find the right versions of the exhibits where they're broken out?
Thank you, Mr. Cowley. Yes, we have.
Thank you.
It's a little bit complicated, but we seem to have mastered it, I think. So no further problems on that front. Right. Let's invite Mr. Gattari to join us.
Okay, we're bringing the witness in.
Good morning, Mr. Gattari.
Hello.
Can you hear me?
Good morning. Good afternoon.
It's afternoon with you, is it?
That's
yes,
correct.
It probably is. Yeah, it is here too now, come to think of it. Do you see on the screen in front of you a witness declaration?
Yes, sir, I see it.
If you're happy with it, would you like to read it aloud, please?
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you.
Mr. Gattari, you've made 2 witness statements in this arbitration, haven't you?
That's correct, yes.
If you wait there, Mr. Cowley, who represents the claimants in this arbitration, is going to ask you some questions.
Thank you.
Good afternoon, Mr. Gattari.
Good afternoon, Mr. Cowley.
If I could ask that document C15 be brought up. Give you an opportunity to see what this is. If we could open it up to the first page. Are you familiar with this green paper that's referenced in one of your witness statements?
Correct, yes.
If I could ask that we go to page 8 of the exhibit. If we look down, the top is a carryover series of bullet points. If you go 3 paragraphs down from there, if I could ask you to highlight that by bringing it up and making it easier for Mr. Gattari to read. Drawing your attention to this, and just to make sure, I should have said this a moment ago, by green paper, that refers to the fact that this was a proposed policy, a version of a policy that was under discussion, but as of this time was not yet adopted as a formal policy of the ministry, correct?
Can you give me a chance to read this text on the screen, please?
Yes.
I can read it now. Yes, I've read it. Yeah.
Okay. And just taking a step back, I referenced the term green paper in my prior question. By green paper, that means that this was a draft of a policy that was under discussion by members of the ministry, but it was never adopted as a formal implemented policy at any time. Is that correct?
That's incorrect, sir. Although we don't use the color coding of our policy documentation, but I understand what you are saying. Nonetheless, this policy document was discussed among various stakeholders in the mining sector, and it was accepted as a consensus document, even though it was never published in the official gazette. Yes.
And in this paragraph, the policy document talks about the government's decision to privatize mineral concessions led to a number of large players entering the market. And it goes on to say that they have determined, they have to determine potential mineral deposits in their large-scale concessions in order to be given a 30-year permit to develop industrial mining. You see that?
I see it, yes.
And at the time that this policy was discussed, it was recognized that for international mining companies to come in and invest in the concessions, the progress between the artisanal mining that was primarily done when privatization started to industrialization of the mining concessions would be a long-term 30-year evolution, correct?
That's not how I understand it, sir. How I understand it to mean is two things. One, this policy to privatize government-owned mining concessions was being implemented in the larger context of the government policy to privatize existing government assets, which included in the manufacturing sector, in agriculture, in tourism, and other areas. And so this was a broader policy to privatize, to get government out of the productive sectors and get private companies to do that. With respect to the mining sector, how I understand this policy statement was that there was a requirement for the private companies participating in this privatization exercise to undertake sufficient mineral exploration exercise that would then allow them to obtain a 30-year permit to develop industrial mining.
And the development of that industrial mining from the artisanal mining that was primarily taking place at the start of the privatization would be a gradual process over the life of the long-term concession, correct?
Industrialization cannot be achieved overnight. It has to have what begins and what comes sequentially after another. If that's what you are asking about, yes, that's correct.
If I could ask you to look, if I could ask you to bring up the supplemental witness statement of Mr. Guattari and go to paragraph 20. In this paragraph of your supplemental witness statement, you acknowledge in the first line that the Rwandan mining industry remains largely artisanal, and part of the goal of professionalization and industrialization means that this will change. There has historically been substantial ability to be flexible, changing demand in the mineral market, to be flexible to changing demand in the mineral market. That reference there is to what you just described as the recognition in the policy that the progress to industrialization would be one step at a time over a period of time, not immediate, correct?
This is out of context, sir. Paragraph 20 in my witness statement was given in the context of explaining how we have been able to realize quick production increases over a short period of time. And I was mentioning here the contrast between small-scale artisanal mining practices and large-scale industrial mining practices. And I was explaining that because of the presence of small-scale artisanal mining operators in our country, we have an industry that is capable of responding to global market changes very quickly because they tend to be nimble. This was not in any way in reference to the existing mining policy in the country, but rather to the practical realities of how companies respond to global market changes.
Thank you. And what I was focusing on is the aspect of the then current recognition at the time of this statement that the Rwandan mining industry still remains largely artisanal at this time, despite adopting a policy some years ago to industrialize it, correct?
There is indeed a coexistence of small-scale mining operators as well as large-scale industrial operators. And this is recognized not only in our policy, but also in our legislations, which issue space for licensing large-scale operators, medium-scale, as well as small-scale operators. So this goes without saying because it's a consistent policy of our country.
And if I could draw your attention to the last sentence in this paragraph, you confirm there that Rwanda's mining industry was and still is dominated by artisanal mining, correct?
By their nature, sir, the artisanal small-scale operators tend to be many. The large-scale operators, industrial operators tend to be fewer, even though if you look at the capital invested, if you look at the production done, even fewer industrial operators can have a scale much larger than several small scale. So yes, I was referring here to the number of operators in our country. Certainly the small scale operators outnumber the large scale ones.
And the timing of this statement where you're talking about as of the present time as of the statement, that was just signed last year, correct?
That's correct, yes.
If I could ask that the initial witness statement be brought back up. I'm sorry, they brought up for the first time. If we go to the original witness statement of Mr. Kachari and paragraph 24. I'd ask you to read that paragraph, sir, and let me know when you're able to answer a question about it.
Can someone zoom it up for me, please? I have read it, yes.
So to focus on the term artisanal mining for a moment, I wanted to reference your description in this paragraph of the context of the mining that is taking place. The first sentence refers to mining in Rwanda takes place in communities. By communities, in fact, you're talking about the concessions themselves in large part, correct? Miners live on the land that makes up the concessions, correct?
No, sir, it's not always the case. For example, in the case of the large-scale concessions, particularly those that have been previously in government hands that were privatized, they were exclusively mining areas, not inhabited areas. But there are some cases where mining operations are close to settled areas of the communities, yes.
So in some instances, miners live on the land that makes up some of the concessions that private companies now own, correct?
Correct.
And in others, the mining area is separate, but right next to where people live, correct?
That's correct. Except that also, even when mining operation is far from settled area, in the broader sense of the community, there is that coexistence of the ecosystem, whether it's with water, with the environment, with forestry and others, because of the specific terrain of Rwanda. So even when it's far, the impact can be felt by the communities, yes.
And the miners who are doing the work that's been described as artisanal mining, these are individuals that live in these communities, either on or adjacent to, in some instances, the concessions, who walk out of their house with hand tools to do their mining, correct?
This is not the case that I was referring to here. Mr. Cowley, you may be familiar with the global trends over the last couple of decades that is often referred to as the social license to operate in mining sector. I was referring here to that requirement by society for mining operators to obtain the social consensus that this mining is acceptable in our community because of the direct impact that mining operations have on the environment, on the communities that live there. And so my reference here was particularly to mean that a sensible mining operator must obtain not only the government's license, but also the community's acceptance for them to operate. And there are many cases around the world, including here in Rwanda, where communities have complained and has led to changes in the licensing rights of the mine operators. That's what I was referring to here.
Thank you for that explanation. And I should say, as clarification, while I appreciate your explaining this paragraph, I was not attempting to challenge or question everything you said in the paragraph. I just used it at the beginning of the question to draw your attention to what you were referring to as communities, so we could explain the relationship between artisanal mining and the communities in which the miners live. That was the only purpose of referencing this paragraph. So without questioning the rest of your points in the paragraph, I'd like to just continue to focus on the miners themselves who are doing the work that we've been referring to as artisanal mining. Just focusing on them. Those miners walk out of their house with hand tools and conduct the mining, for minerals that we've been referring to as artisanal mining, correct?
So sir, artisanal mining is not about people and communities. Artisanal mining is about methods used, regardless of whether these are employees who are in mining camp or whether they are people coming from their homes. We refer to artisanal mining as a way of doing things. The kind of tools they use, the practices that they use to extract minerals, which tend to be using very simple rudimentary tools, often in very unsafe mining environments, very unproductive and wasteful, that harms the environment. And so I wouldn't use people and where they live, but rather on the methods used in extracting the mineral. That's what we mean by artisanal mining, as a method rather than people.
Thank you. And I'd like to focus on the miners that were conducting mining activity on and around the NRD concessions while they operated those under those licenses. These were people that were going out every day and by hand conducting mining activities described as artisanal mining because they needed to obtain minerals so they could sell them and earn money for their family to live on, correct?
So artisanal mining as a practice is only recognized in the context of licensed people. When they are, let me put it differently, they are licensed companies that have formal rights to operate mines that use artisanal methods. And these companies sometimes use labor that comes from far and they live on the mine. Sometimes they may use labor that is coming from the community around where the mine is. So it's not always exclusive that the miners will be from around that community. Many times they are brought in from far. But okay, with respect to artisanal mining, we refer to the methods that they are using, not exclusively to those who are living near the mine.
Okay, so I'm just going to refer to miners. And what you just described as some of the miners are made up from people coming from a distance. Some of the people who are the miners live in the either on the concession or the communities right next to it. That was true of NRD when it operated under its licenses, correct?
I can't comment on that. I actually have, I was not actively following on NRD activities on the ground, but given the reports that I have read and statements that I have seen from various individuals, NRD had a mix as well of miners, some that lived near to the mines and some that came in from far.
Okay, and you're familiar with the period in 2014, beginning, I should have said, beginning in 2014, when then Minister Avode barred PACT from issuing mineral tags to NRD to use in selling minerals, correct?
I have seen some correspondences to that effect, yes.
And do you recall how long that lasted?
No, sir, I have no recollection. I don't have memory of that. Yeah.
Do you recall NRD being given back the opportunity to obtain tags and continue selling minerals at any point?
I'm not aware of that. I have no recollection. I wasn't following it.
Okay. For the period of time that that Minister Avode did prevent tags from being issued to NRD, the government understood that at least as to those miners who had been doing their daily activities at the NRD concessions because they lived very close to those concessions, that those people still had to go out each day and do the same type of mining to obtain the same types of minerals if they were going to obtain cash for their families to live on, correct?
I'm not aware of that. In any case, if the formally licensed company was no longer operating in the concession, then there is no one allowed to operate that concession until it's fully licensed. If anybody was going to go on that concession to mine any minerals, it would be illegal and they would have to be punished by the law.
Where did the government think the people went when the tags weren't delivered to NRD to use to sell minerals? Where did the miners go?
Mr. Cowley, that's a question I'm not able to answer, but I can tell you that mining communities from whom labor comes from to go and work on the mines are not concentration camps. Often those who live in the communities also have other economic activities because they live on their land, they have agriculture. In fact, the experience we have is that labor in mining sector tends to be seasonal, increases in the dry season when agriculture activities are low, and reduces during the rainy season when they have to work on their agriculture fields. So it would not be unusual that whoever was no longer working at the NRD mines would have their farms to work on and do agriculture work on their fields.
Because a portion of the miners were made up by individuals who were also had agricultural fields that they operated and had invested their time in, you knew they weren't going to leave just because tags stopped being delivered to NRD. They were going to stay, right?
So these are questions that perhaps would be best asked to Mr. Evode, but I can tell you in general terms, as a government official knowing how people live, that if there were people laid off from mining and they were living on their land, they would have opportunities to continue to work on their field for agriculture. And if there were any individuals that would have any ideas to carry out illegal mining activities, I can assure you that they would not be tolerated because the local administration would have a responsibility to stop that.
Well, just as a matter of common sense, the government understood that even though NRD could no longer buy their minerals and sell them using the tag system, these miners needed to mine and sell minerals. So it was taking place. Wasn't that understood?
I don't understand the question. So could you repeat it? Maybe you can ask it differently. I didn't quite pick it.
You just told us that if it happened, it would have been against the law for these miners to go out and continue to mine and obtain minerals once NRD lost its rights to the concessions. I'm actually focusing on the period where it was on the concessions, but lost the ability to have lawful tags applied. So the same point, there was no lawful way to sell the minerals under the tag system. Despite your statement that you knew it would be illegal, just as a matter of common sense, you knew these people had to keep doing it, right?
That's incorrect, sir. There's no such thing as a common sense that leads people to do illegal activities. Absolutely not. If people had lost their job at NRD and they are no longer employed at the mine, it means they don't have a job at the mine. It means they must do alternative economic activities to get their income. And I'm saying if there are people who were working there and live in the communities, have the agricultural land, that would be the alternative for them to do. So it's not a common sense to say that the next thing to do is to go and do illegal activities. And I've said if anybody went to do that or thought of, or considered to do that, they would immediately understand that it's illegal and the local administration would have to stop that.
Did the government of Rwanda ever look into whether the miners who had been mining on NRD's concessions while NRD was given tags continued to mine on those concessions when the tags were taken away from NRD and just found some other way to sell their minerals for money for their families?
So, sir, let me explain. Minerals are not eaten. They can only be used in industries. And so, yes, if anybody was going to carry out mining, it would be for selling them. But for minerals to have access to the market, there is a requirement in Rwanda to have them tagged. And there are no individuals that have access to tags. Tags for minerals are only issued to fully licensed companies that are in operation. So if NRD was no longer operating their concession and they don't have access to tags, the minerals will not have any tags, and that goes without saying. They have no access to the market.
Well, that's why I'm asking these questions. And what I'm asking right now is, didn't the government ask these very questions? Because if it was taking place, that would suggest everything you just said about how the tagging system is supposed to work may not, in fact, be how it's working on the ground. If miners can go out, mine minerals just like they did every day under the NRD concessions when NRD had tags, and find ways to sell them to people who could get them into the stream of commerce anyway. Didn't the government ask this question and look into it?
So the government of Rwanda cares about its people, and we always care to make sure that they have gainful employment and income. So I'm aware that when NRD was no longer operating their mining concessions, it was important for the government to quickly find alternative companies that could take up the concession so they can provide employment to those who had lost their jobs.
And how quickly did that happen? After NRD lost the ability to apply lawful tags to the miners' minerals, how quickly did the government get another operator in who had such right and could pay those miners?
So I need to check. I don't know how long it took, but I can check that and come back to you.
I'll come back to that question.
Sure.
Can I ask that the supplemental witness statement be brought up at paragraph 18? And the third sentence highlighted. Well, sir, I'll let you read this paragraph first before we do anything else, and tell me when you're ready to answer a question.
I have read it.
Now, if the third sentence could be highlighted, I'd appreciate it. So focusing just on that sentence of that paragraph talking about the ITSI tagging system and comments that were made by the claimants about how production numbers, as the claimants count them, suggest more minerals are going out of Rwanda than are actually mined in Rwanda. You explain that, in fact, the system is tracked closely, and you describe here, at least in part here, I think there's other paragraphs as well, but you describe what you mean by how the system works. And here you say that production figures are reported on a mine-by-mine basis. So by that, you mean within something like NRD's licenses when it was operating under them, there were 5 concessions. you could actually track concession by concession, how much of a particular mineral was mined in a given time period compared to other minerals mined at that concession in the same time period, and compare that to minerals mined at the other NRD concessions by mine, correct?
That's correct, yes.
And if I could ask that R118 be brought up. Just to orient you, are you familiar with this document, sir? And we could give you a chance to look at it. I don't have specific questions about anything other than one section, and I'll bring it to you and highlight it. But I want to make sure you're comfortable, you know what document you're looking at in case you recognize it.
Can I have a look at the title and who wrote it, perhaps? Maybe it would help me.
Yes, my memory isn't the sharpest, at least right now. I'm a little bit tired, so I can't say that the name is on there, but I believe it's not contested that Dr. Mike has explained he wrote this.
So I'm not familiar with this document, but you can ask the question you want.
That's all. Well, right. And I just wanted to make sure. So I'm going to ask now that we turn to page 3, and there's a chart on that page. And highlight the chart and the language under it. There you go. So I'm going to ask you questions about this. So within that document, Dr. Mike summarized some data in this chart form. And that's a few different types of minerals that were being mined on the NRD concessions over different years, correct?
I can see the figures, yes.
That's what it says. And it specifically cites the source, and I want to break that apart to see that you might be familiar with what he's referring to, even if you didn't do the document and aren't familiar with these numbers. I'm focusing more on the sources. So he says for some of the years, the data is sourced from NRD itself. It's provided by NRD. Are you familiar with how the concession licensees reported data about the production on their mines to the government?
I am not familiar with how they reported prior to 2011, and I will explain. The year 2011 is when the ITSCI traceability system started to operate in Rwanda. And since that time, we established a very accurate network of data collection where each volume of mineral that is produced at the mine site is bagged and tagged with a unique tag, which is identifiable with the volume in the bag. Since that time, data has been collected, simultaneously kept at the government offices as well as at the ITSCI offices. Prior to that time, I'm not familiar with how data was collected from the mining companies and shared.
Now, when we just looked at your witness statement and the language about production being identified mine by mine, you're talking about the 2011 to today current system that you refer to as taking place under ITSCI, correct?
That's correct, yes.
Okay. So for portion of this time period, that didn't apply, and there's 2 years where it does, correct?
Yes, again, depending, I would have to check which month in 2011 when ITSCI system started operating. So I am not confident that it started in January 2011, but anyhow, from whenever ITSCI system started, I can comfortably say that the bag and tag system has been able to also accurately reflect on the mineral production figures. Yes.
So focusing again is where I started the question about the data provided by NRD itself, even though you said you didn't know the details of how it reported. were you at least familiar with the concept that the licensees of mining concessions had an obligation to report their production on a regular basis from their mines to Minarea?
Yes, that would be a reasonable expectation, yes.
And that agency collected the data and it held the data itself. So in addition to NRD having this information, Minarea should have had its own set of this data if NRD complied with its obligations to report.
That's correct. Yes, if NRD or any other companies had provided the data, then it would be reasonable to expect that the institutions who received it would have it.
And then from 2011, whenever in the year it started, following it, at least this says 2011, 2012 data provided by RNRA. So let me focus on that first. RNRA is the Rwanda Natural Resources Administration. Is that correct?
Authority, sir. Natural Resources Authority.
I apologize. Thank you. And is the ITSI, the bagging and tagging and reporting system, operated under RNRA?
Now, RNRA has evolved. It used to have a department called the Department for Geology and Mining. That's the one which followed on the minerals. And it had other departments, land, forestry, water, all natural resources. It has since evolved to become what I lead today, the Rwanda Mining, Petroleum and Gas Board.
Okay. This says those 2 years data was provided by RNRA. Do you know whether RNRA in those years collected the data that the ITSI system was producing from its bagging and tagging system about production at each mine?
That's correct, yes. In fact, ITSI keeps a duplicate copy that government also receives.
And who receives it today? You said it progressed to a different department, but who today holds all that data reported by the ITSI bag and tag system?
The institution that I lead.
And that institution, RDB, has data from that system on a mine by mine basis, correct?
That's correct, yes.
And you do know that the claimants have made a point in this case about the fact that the government of Rwanda chooses on an annual basis not to report that data on a mine by mine basis, but collectively for the whole country. So no one could go back and test, no one with just the publicly reported data could go back and test to say, well, that's not actually what they produced, it's a lot more, because you can't attribute any portion of the total to one mine on your own, correct?
It's incorrect, sir. The fact that there is no publication of the mine by mine production data does not mean that it does not exist, and neither does it mean that there is anything to hide. It's just that there has never been a requirement to do that. And moreover, to do it that way would require to publish individual company confidential data that would require you to ask for their consent. However, if anybody wanted to go and find out, obviously every company would be happy to, or if you complied with their requirements, to have access to it. Now, as government, we have never found a necessity to do that, because on the one hand, we have export statistics, and on the other hand, we have got import statistics, and it's very easy and clear to attribute the difference to local production. Now, moreover, we have a system that traces from the mine upward, aggregating each mine with the other. to the point of export that gives us confidence in our numbers. So only a cynical mind would question our numbers, but they are verifiable, they are accurate.
Thank you for that explanation. If I could ask to return to the supplemental witness statement. And section 7 that begins on page 7. I'm sorry, section 4 on page that begins on page 7. Can this be, I don't know if it could be enlarged at all as one page, but Mr. Guattari, are you able to read this? I'm going to draw your attention to 2 paragraphs, but I want to make sure you know what you're looking at.
Which paragraph, sir?
I'm going to ask you questions about paragraphs 25 and 26. But do you recall giving testimony in your witness statement about the process by which a mining company, if it's asked to return its rights to, if it's asked to return concessions to the government, actually doesn't have a formal process? You said, this is how it works. And you described in these paragraphs what happens. Do you recall giving that testimony?
Correct. Yes.
And if we could bring down to 25 and 26. And after describing what you understood were the formal rules of it, you then say, in essence, how the process works. You say, really, it's notification, and then the government gives the licensee, the former licensee, 90 days to take care of its loose ends and final business. And then after that, the government is free to take possession itself, occupy itself. It gives 90 days, more or less, you describe as a courtesy, but then it's free to go in and occupy itself, correct?
That's an incorrect characterization of the process, sir. What I was describing here is the wrapping up process, the closure process, the exit process from a license holder, regardless of what has caused the end of the license period. And I explained that a license holder can voluntarily decide they no longer wish to continue operating a mining license, or it could be because they have not met compliance related regulations, and they would have been due process to arrive to the conclusion that this has got to end. And how that ends is that it starts by an official notification, which would include the circumstances that explain the end of this license. And then it would go ahead to give the official period of the company to actually conclude their presence at the mining concession, which at the end of which there is no additional relationship between the company and the government. Yes.
And in fact, after this description of those same events in the information in the language that was used in the supplemental witness statement, you get down to paragraph 26, which I believe is the last paragraph in that section. And you start by saying, as a practical matter, there are no formal procedures required other than the notification. So as you described, it could be notification in some instances from the license holder. It might have to formally notify the government that it was giving up the license and leaving, or it could be that the government had to give notice to the license holder that it lost its rights under the license and had to leave. But other than that, you say there's no formal procedure, correct?
What I mean by formal procedures is the kind of protocol procedures of handover of this or that, people coming together to receive a concession back or whatever. there is no formal event that concludes that relationship. The notification requires the company and it gives the company an opportunity to wrap up their operations properly, to meet some of the outstanding obligations, whether it's with their employees or whether it's with their suppliers or whether it's with other institutions and companies they may have had relationship with. Of course, the company has got also a right to request additional period if they feel they have not concluded what they needed to do. But other than this notification and the company carrying out those, concluding those obligations, there are no formal events associated with this exercise.
And in your testimony, you say that that means you wouldn't even expect much dialogue if it got to the end point where the government was asking the licensee to leave. And within 90 days, the government could occupy without anything else happening other than that formal notification, correct?
If indeed the company has not requested any additional time for them to conclude any outstanding obligations, then indeed it would be expected at the end of that notification period that the concession is back in the hands of the government. Yes.
I could ask that C38 be brought up. This is a May 19, 2015 letter from then Minister Avod Spalena to NRD. Have you seen this before?
Can you zoom it up, please, for me to see? My sight is not as good as it used to be.
I can relate very well to that.
What's the date of this document, please?
May 19, 2015.
Yes, I can see it. Yeah, thank you.
You familiar with this letter?
I can't recall it, but I can see that we were copied at Rwanda Development Board. Yes.
And you saw the, as you just read it, you saw the last paragraph in the letter in which Minister Amena stated that NRD is asked to hand back over the concessions, correct?
Can I see that? I did not read through the document. I was scanning through the beginning and end.
Please highlight the last paragraph of the letter on the second page.
I can see that, yes.
Based on the description we just read in your witness statement, it's accurate to say, is it not, that after sending this notice, Minister Amena shouldn't have expected any further dialogue with NRD, but after waiting, whether it's the 60 days that he says or the 90 days that you say, after waiting that notice period, he understood that the ministry was then free to occupy the concessions itself with nothing further from NRD, correct?
This seems consistent with what I was describing.
I'd like to touch on one point in your first witness statement. You give a bit of a description of the background of first, as it started, RIEPA, and then what then went into your department, your group in RDB. You gave some testimony about the interest in obtaining foreign investment in Rwanda throughout a number of industries over a long period of time, and that you were looking for people willing to assist, people willing to invest broadly, not specifically to Mr. Marshall, for example. You challenged his statement about his specific solicitation, and you described how there was broad solicitation of investment and interest in a lot of industries, correct? Do you remember that?
Sorry, I'm not sure I understand the question.
Okay, poor question. I'm trying to race here, and I shouldn't. Do you recall that in your first witness statement you described the background of your department working to get foreign investors in a number of industries within Rwanda?
Correct. Yes.
Including the mining industry, correct?
Correct. Yes.
And because you wanted foreign investors to come in and be successful, you did not, the government of Rwanda did not place any prohibition on such investors from selling their shares to other investors over time, correct?
Prohibition, I'm not sure I understood. Can you repeat that last part, please?
Yes, when your group was working with investors to come in and invest in companies in Rwanda to do business in various sectors, you didn't put any restrictions on those investors from then selling their shares to others who might want to pay them more for it or pay them whatever for it, correct?
No, no restrictions, no.
Because you understood if you placed restrictions on investors' ability to sell their shares to others, it would make it a much less attractive investment for them to ever put any money in the first place, right?
That is reasonable, yes.
How many mining concessions were privatized in the 2005 to 2010 period? And I use the term concessions. Now, I didn't ask how many licenses were issued, but how many mining concessions were privatized?
I can't recall, so I wasn't even actively involved, so I can't give a number, but there are quite a number of them, yes.
One last document to ask, if I could ask to bring up, C-132. Take a look at this document, sir, to refresh your recollection about it.
Can you go to the bottom of the document, please? Further down, please. I'm trying to see if it's the one I'm thinking about. Yes. Okay.
Do you recall in your supplemental witness statement discussing your impression of this document? You conclude that you don't think it was actually signed by Riepa and Mr. Marshall?
I recall seeing this document in Mr. Marshall's allegations that this was indeed signed by my predecessor, Mr. Williams Nkurunziza, and I have questioned it on a number of grounds. One, when I succeeded Mr. Williams Nkurunziza as Director General of Riepa, I never received this as a handover relationship. Which,
can I ask you about one ground only? I wanted to focus on the document because I have a question about one of the grounds you gave, as opposed to, I'm not asking you about all your testimony. It's in the witness statement, but you did mention as one of the grounds that you said the date of January 12, 2004 is referenced by Mr. Marshall. You think shows that this document's inaccurate because Riepa didn't exist in January. It came into existence in September 2004, correct?
Correct, yes.
Now, isn't an equally plausible explanation for that fact that you noticed, instead of Mr. Marshall lying about this document actually being signed, the fact that Mr. Marshall, an American lawyer who had been living in Europe, coming to Rwanda in 2004, signed, or excuse me, dated a document using the American month, day, year reference instead of what is familiar from our documents as the Rwandan accepted day, month, year system. So when he looked back at it all these years later, he said January 12th instead of December 1st, 2004. Isn't that equally plausible to making up the whole document?
I can, if I do not know the American official
Not
way.
sure that the witness is the right person to answer that question as opposed to the tribunal.
Thank you. No further questions.
I have no re-examination.
Thank you very much, Mr. Qatari. You're now free to go.
Thank you, Mr. President.
Presentation from Mogisha. It's been emailed to us just now. He also asks, Alexa asks, whether the claimant's expert should deal with the expert declaration or the witness declaration.
FTI, please mute the tribunal. I believe the tribunal is ready to be unmuted. Excuse me.
I just sent a unmute request. Somebody's going to have to unmute from Zoom at the tribunal location.
Is Cassius there?
Yes, I'm sending him an email.
Oh, I think Ms. Doman is.
Yep. There we go.
Can you not hear me now?
Now we can hear you.
Unmute.
We can hear
Can.
you. Yes.
Right. Mr. Hill, can you hear me? We can't hear
Yes,
Mr. Hill.
yes, I can hear you, Mr. President. I'm sorry, I was on mute
Yes.
myself.
I'm sorry, you want us to unmute?
No,
everybody
I think
is-
we can all hear each other now.
Right. What was that all about?
So the first question is, should the
Uh,
expert
Yeah, I understand that, but why did they ask us to unmute?
Mr. President, I think the
Yes.
FTI system muted you so that your discussions couldn't be heard by us, and then there was a mechanical problem getting you unmuted, I think.
Oh, I see. I see. All right. Is Mr. Wamasirabo ready to give evidence?
That's
I
my
can't hear you,
understanding. I was waiting. I didn't hear Mr. Kaplan specify whether he's in the room and he's connected with FTI, but that's our expectation. He was to be available. at this-
Yes.
He
Yes,
is,
please go ahead, FTI.
apologize. Yeah, he is sitting in front of his system. I can see him on the 360 camera and he's in the waiting room. So we should be able to bring him in.
Well, I suggest we give him the ordinary witness declaration,
Mr. President,
notwithstanding the fact that some of his evidence relates to law.
Yes,
We've got to
Mr.
do
Pre-
one or the other. Yes,
Mr. President,
Mr. Hill.
the examination of this witness is going to be conducted by Mr. McCarthy on behalf of the respondent rather than by me. So he will appear on camera in a moment.
Thank you.
Before we start, can I just ask what time I should pay attention to? Or the question is going to be done by someone else, but what time should we be paying attention to for the break?
We'll proceed for about 3/4 of an hour. And then we'll break for half an hour.
Would you like me to bring the witness in, Mr. President?
I would, please.
One moment, we're bringing the witness in.
Is there
It
some
shows-
problem?
It shows his video is connected, but we're seeing a black screen.
Yeah,
Yeah.
it's still coming in. His internet connectivity is very, very weak. We may have to turn off his 360-degree camera in order to save bandwidth.
Council, members of the tribunal, may we do so that his
Yes.
bandwidth is.
Was that a yes? I apologize. I didn't hear.
Sorry, it was a yes.
Okay.
That helped. Mr.
Good,
President is available.
Good afternoon, Mr. Ramasarabo. If you
Good
would please
afternoon.
look at your screen, and there is a witness declaration that's normally designed for a witness of fact, although it seems to the tribunal that some of your evidence relates to matters of law, but we've decided that we would invite you to repeat this declaration if you are happy to do so. Aloud.
I'm happy to do so.
Yes, please will you then repeat the witness declaration?
Sorry, I
You see-
didn't get you.
Could you look at your screen
Yes,
and do you see a witness declaration?
I cannot see it.
Oh,
One moment.
Okay, yes. Sorry, yes. Oh,
I was explaining that is a witness declaration that is designed for witnesses of fact. Some of your witness statement is dealing with law, but we have thought it appropriate to invite you to make this declaration if you are happy to do so.
I'm happy to do so.
Well, then, would you please repeat it aloud?
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you.
Good afternoon, Mr. Ramasarabo.
Good afternoon.
I'd like to start by asking you some questions about the contract. Operator, if we could have up Exhibit C017. And this is the contract made between NRD and Rwanda for acquiring the mining concessions.
Yes.
Yes?
Yes.
Sorry, I can't hear Mr. Ramasarabo.
I said yes, I can see it on the screen.
Did you hear anything?
Hello?
Mr. McCarthy, did you hear the answer?
I didn't hear the answer. Sorry. No, we had a little problem here. Sorry.
Right.
I think we're okay now. And Mr. Ramasurabo, Article 2 of the contract sets out certain obligations on NRD.
Sure. Yes. Can you just scroll down so that the article 2 can be visible? Scroll up. Yeah. Okay.
Article 2.2 required NRD to provide the action plan, the environmental protection plan, and the investment plan.
Sure.
Article 2.3 required NRD to proceed immediately to the industrial exploitation in all given sites.
Sure.
And Article 2.5 required NRD to provide reports of reserves and the feasibility study after 4 years.
Sure.
Excuse me, Mr. McCarthy, we're getting a lot of feedback. Is there another system in your room that the speaker is on? Because
Yeah, I think, sorry, if we can just take 30 seconds to sort that out, sorry. Is that better?
yeah, it appears to be better. Yep.
Thank you. And if we could have a look at Mr. Samarabo's first witness statement at paragraph 5, please, operator. If we could look at that side by side with the contract. And you say in paragraph 5 that once one party to a contract performs, that party is entitled to all benefits owed to that party under the contract.
Can you repeat that, please?
You say that once one party to a contract performs, that party is entitled to all benefits owed to that party under the contract. That's your first sentence, yes?
True.
And you say in the next sentence that NRD was obligated to proceed immediately to the industrial exploitation and to perform the other research and planning activities.
True.
And you're referring there to the obligations under Article 2 of the contract, which we've just looked at, and you can see on the slide.
True.
And you accept that NRD had to perform the obligations under Article 2 before it would be entitled to grant the mining concessions.
True.
And it follows that if NRD didn't perform its obligations under Article 2 of the contract, it would not be entitled to the grant of the mining concessions.
True.
And therefore, there was no guarantee under the contract that NRD would receive the grant of the mining concessions, regardless of its own contractual performance.
No, what I meant in this on that paragraph is that as long as NRD perform the contractual obligations under Article 2, they will be entitled, they would have a right to a long-term contract.
Yes, Mr. Ramasuraba, I think you agree with me that under the contract, there was no guarantee that NRD would receive the mining concessions regardless of of its contractual performance.
There will be a guarantee as long as they have performed their contractual obligations, and the other party will also have to fulfill its contractual obligations since NRD had performed them.
You accept that NRD had to perform its obligations under the contract?
Of course, and which they did.
or Mr. Ramsarabo, that's a factual assertion. We'll come to that a bit later on. For now, I'd like to move to Articles 3 and 4 of the contract. And if we could focus on that again, operator. Now, the French and English versions of the contracts have slightly different meanings, but under both versions of the contract, NRD was first required under Article 2.5 to submit a feasibility study.
Sure.
And both versions required a positive evaluation of the submitted feasibility study.
Sure.
So that required the government to consider the feasibility report submitted under Article 2.5.
Sure.
And it was for the government to deem the submitted feasibility study was satisfactory.
Sure.
Now, operator, if we could look back at paragraph 5 of Mr. Ramsarabo's witness statement. In paragraph 5, you make no reference to NRD's obligations under Article 4 of the contract.
Sure.
The government's obligations under Article 4 were also conditional on the positive evaluation of the feasibility study.
It was one of the obligations that NRD had to fulfill.
If we could have a look at paragraph 6 of your witness statement, operator, please. You say there it was common knowledge in the mining industry that once a mining company obtained a contract for mining licenses, it was guaranteed long-term concessions at the end of the original 4-year term.
Sure, yes.
But you yourself are not a member of the mining industry, are you?
I'm not a member of the mining industry, but I've experienced in the mining sector. I've other clients in the mining sector, and I have that knowledge.
Yes, you're not a member of the mining industry, and you've taken this point on instructions from the Claimants Council, haven't you?
I beg your pardon, Daniel?
You're not a member of the mining industry, and you've taken this point on instructions from the Claimants Council.
No.
You've put forward no evidence to support your assertion as to what was common knowledge in the mining industry.
It is, I've given that statement based on my knowledge of the Rwandan mining industry and what the practice has been.
And you're not properly in a position to make that assertion.
I believe I have the knowledge, I have the skills, and I've worked in the mining industry, and I've followed closely the mining sector in Rwanda.
We'll come to your background a bit later on. For now, I want to have a look at Exhibit RM001. Sorry, RM001, please. Sorry, we still don't have the right document. Exhibit RM001, please. Should be the 2011 law governing contracts. Thank you. If we could go to page 50 of the PDF, operator. If we could focus on Article 77. So this is Article 77 of the Rwandan 2011 law governing contracts, yes?
Yes.
And it defines a suspensive condition.
Yes.
And this is an event which must occur before the performance of the contract becomes due.
Yes.
And an event may be a suspensive condition either on agreement between the parties or by an order of the court.
Yes.
If we could also look at the same time, operator, at C017, again at Articles 3 and 4, if that's possible, please. The positive evaluation of the feasibility study. Thank you, operator. The positive evaluation of the feasibility study was an event which had to occur before the government would be required to perform its obligations in respect of mining concessions.
Yes.
The positive evaluation of the feasibility study under Article 4 was therefore a suspensive condition under Article 77.
I don't agree with that.
Well, Mr. Ramasaraba, you agree that it's an event. You agree that it's an event which must occur before the performance of the contract becomes due. It's plain from the language. Sorry, can I just finish the question? It's plain from the language of the contract that this is a suspensive condition, isn't it?
It's not mentioned anywhere that it's a suspensive condition of the contract. If you look at Article 77, paragraph 2, this event, which is the feasibility study, positive evaluation of the feasibility study, should have been an event that was agreed upon between the two parties before that, or by a court order. And we do not see anywhere in the contract where it was agreed between the parties, okay? And we neither do we even have any court order in that regard. So that is why I cannot, I don't consider this to be a suspensive condition, rather executory.
Mr. Ramasaraba, the parties have agreed the terms of Article 4, didn't they?
Yes, but they did not agree that it should be a suspensive condition. It should be explicitly mentioned in the contract, like many other contracts where you find suspensive conditions.
And Article 77 says nothing which requires a suspensive condition to be expressly labelled as such in the contract.
But it wasn't agreed between the parties at the beginning.
Mr. Ramasaraba, if you could just focus on my question. Article 77 does not require that a suspensive condition be explicitly labelled in the contract, does it, as such?
But I get you, but it requires that that suspensive condition should be agreed between the parties before that.
Yes, but just focus on the particular requirement which you've asserted, that it must be expressly labelled. There is nothing in Article 77 which requires a suspensive condition to be expressly labelled as such in the contract. Yes?
There is nothing, but Article 77, paragraph 2 requires that this should be agreed between the parties, and this was not, it wasn't done before that.
Operator, if we could go down to Article 78, please. And this sets out the effect of the non-occurrence of a suspensive condition.
Yes.
And pursuant to Article 78 of the law, non-occurrence of the suspensive condition extinguishes the obligation under the contract.
Yes.
And so if the requirement for the positive evaluation of the feasibility study was a suspensive condition, if it was not positively evaluated, the government's obligation to grant long-term concessions was extinguished.
Yes, if it was a suspensive condition.
If we could go to Mr. Ramasarabo's first witness statement at paragraph 7, please. don't think we've got the right witness statement, sorry. Mr. Ramaswarabe's first witness statement, please. Thank you. You say that there's a Rwandan administrative practice that if one party fails to contest the other party's performance, it is deemed to be an acknowledgement of performance.
Yes.
And you say that Rwanda did not object to NRD's performance under the terms of Article 4.
Yes.
And you say as a result, Rwanda NRD's performance was deemed to be acknowledged.
Yes.
And in paragraph 7, you cited no provisions of Rwandan law in support of the propositions you make there.
Yes.
Operator, if we could get exhibit C062, please. And this is a letter dated 2nd of August 2011 from Minister Kamanzi to NRD.
Yes.
And the letter expressly states that Rwanda considered that the contract had not been fully executed.
Yes.
More especially as to Article 2, as regards the presentation of the final report and the mining feasibility studies.
Yes.
So Rwanda did object to NRD's performance under the contract.
In that letter, yes.
You've also ignored other examples in the evidence which record Rwanda's dissatisfaction with NRD's performance of the contract, haven't you?
No, I have not. I did not see, even prior to that letter, I did not see anywhere where the government had objected to the performance of NRD. And this letter came almost a year, almost 1 year after NRD made the right application in time and in full.
And you've also failed to mention that Rwanda proposed to NRD that it would be prepared to negotiate on only 2 of the 5 concessions because its performance under the contract fell below what was expected.
Nope.
Well, if we can go back to paragraph 7. And operator, I think if we could have paragraph 7 and exhibit R018 up at the same time, please, of Mr. Ramaswarabe's first witness statement. And on the right-hand side is a letter of January 2012 to NRD, again from Minister Kamanzi.
Yes.
And again, is making clear that Rwanda's contractual performance in the second paragraph fell short of what was expected.
Yes.
And if we look back at paragraph 7, you fail to mention exhibit C062. Yes.
Can you repeat?
There's no
that?
reference there to exhibit C062 in paragraph 7.
No.
Correct?
No, yep.
And there's no reference to exhibit R018.
Nope.
And your first witness statement at paragraph 7 is wrong when it suggests that Rwanda did not object to NRD's performance under the contract.
I don't fully agree. If I don't fully agree because this partly came almost 1 or 2 years in silence, 2 years keeping NRD in total silence, 2 years of inaction, and I consider that as not having exercised due process in terms of making the applicant know within the time provided by the law. If you look at the 2008 law, there was a prescribed time which the Ministry of Natural Resources had to respond to the applicants. So in my assessing this application and the response that came more than a year after the application, I considered it that they had not objected to the NRD's performance within the due time, within the normal time, the normal practice within that sector.
If we could have our operator, instead of R018, could we have our 106, please? Sorry, if we could keep, it would be helpful, sorry, to keep the witness statement and have R106 instead of R018, please. Sorry, I think we have the wrong exhibit operator. It should be R106, please. We'll come back to the contract if that's too complicated, sorry. Thank you. Yeah, sorry, operator, it's R106 is the document we want. And this is a letter in 2009 to NRD from the minister. And at paragraph 4 is requesting a report on why you cannot meet the obligations. Oh, sorry, on why NRD cannot meet the obligations.
Yes, I can see.
And again, Rwanda was calling into question NRD's performance of the contractual obligations.
Yeah, I can see that.
And looking back at paragraph 7, your statement is wrong when it suggests that Rwanda did not object to NRD's performance.
I don't believe it's wrong because even after 2009, NRD continued to get several extensions of the mining concession, and I don't think any regulator can extend mining mining licenses several times if the company is not performing.
You've made an unqualified, an unequivocal statement in paragraph 7 that Rwanda did not object, and that's wrong.
It did not object within the prescribed time, okay? Especially with regard to when they were examining the application of the long-term contract.
and it's wrong to suggest that NRD's performance under the contract was deemed to be acknowledged.
It's not wrong.
If we could have a look at Mr. Ramaswarabe's third witness statement, please. Paragraph 6, please. And you say here that you disagree with Mr. McGeish's conclusions that the contract was not extended. You say that each time Rwanda extended the licenses, expressly or implicitly, it also implicitly extended the contract.
Yes.
And again, you've cited no provision of Rwandan law to support the assertion that extensions to the licenses implicitly extended the contract.
This was on the basis of Mugisha's assertion that as long as the contract was not valid, he wouldn't get, the NRD wouldn't have a mining license. So in essence, the contract, the license stemmed from the contract. So if they continued, the government continued extending NRD's license, implicitly, it was, the contract was still valid.
My question, Mr. Ramaswarabe, was that you've cited no provision of Rwandan law in support of paragraph 6, have you?
No.
If we could go down to paragraph 7, please. Again, on the fourth line, you say that the contract was implicitly extended with each extension of the licenses, or you say the licenses independently grant the right to conduct mining operations at the concessions covered by the licenses.
Yes.
But it's right that the licenses only granted the right to conduct mining operations only whilst they remained on foot.
Can you repeat your question, please, Daniel?
It is right that the licenses only granted the right to conduct mining operations whilst they remained on foot.
Could you qualify while staying on foot, please, for me to understand clearly your question?
So prior to the period before they'd expired?
Yes.
Yes, you agree?
I don't agree.
Well, it's right, isn't it, that the licenses only grant the right, the right to conduct operations when the license is valid?
If you are granted a license, if you and when NRD got extension of license, it had the right to mine, to carry out mining operations in all the concessions for which they are granted the extension.
But if the licenses no longer remained valid after they'd expired, there's no right to conduct mining operations.
I don't think so. But if also the regulator does not stop the holder of the mining license, even if it was expired, and is made to believe is left to continue operating, to continue mining, I take it as implicitly letting the company continue to do their operations.
And you've not made that point in your witness statement, and you've not cited any provision of Rwandan law to support that.
I responded to your question, Mr. Daniel.
Mr. Ramaswarabe, if we could now consider due process. An operator, if we could get up Mr. Ramaswarabe's first witness statement, paragraphs 9 to 12. And in paragraphs 9 to 12, you make various...
I think I think, Mr. McCarthy, if you're getting into a new topic, it might be a convenient moment to break for 30 minutes.
Sure.
Okay, we're going to go ahead and open up the breakout rooms right now. Okay, Mr. President, the witness is in the waiting room. I will go off camera and wait for you to request the witness be brought in. It appears you are on mute, Mr. President. When I'm going to send an unmute request, someone's going to have to go up to the TV and unmute. There we go. There we go.
Right, you should hear me now.
We hear you.
Yes.
I have a very good technical assistant. Yes.
May we bring in the witness?
Yes, please.
Okay, we'll
Thank you. Yeah.
bringing him in now.
Yes, Mr. McCarthy.
Thank you, Mr. President. Mr. Ramaswamy, I'm going to ask you some questions about due process. Operator, please could we have Mr. Ramaswamy's first witness statement at paragraphs 9 to 12? In paragraph 9, you say that Minister Aminia's failure to hold negotiations with NRD was a violation of NRD's rights of due process under Rwandan law.
Yes.
In paragraph 10, you say that under Rwandan law, a failure to initiate negotiations following an invitation to negotiate is a violation of due process.
Yes.
And paragraph 11, you say that Minister Amina violated NRD's rights of due process when he requested NRD to submit documents in support of the application for concessions under the 2014 law.
Yes.
And in paragraph 12, you again make the allegation that a refusal to meet with or communicate with NRD was a violation of due process under Rwandan law.
Yes.
In paragraphs 9 to 12, you've cited no provisions of Rwandan law in support of the propositions you make in relation to alleged violations of due process.
Yes.
Operator, if we could get up Mr. Magisha's first report, please, at paragraphs 53 and 54. That's page 14 of the PDF. Thank you. Sorry, this doesn't appear to be the correct document. It's Mr. Magisha's first expert report, please. I think that's his witness statement. And at paragraph 54, Mr. Magisha explains that there is no such law in Rwanda that a failure to initiate negotiations is a violation of due process?
Yes, I can read that.
And paragraph 56, Mr. Mugisha says there is no codified law on due process in Rwanda.
I can read that.
And Mr. Mugisha also says that the requesting the submission of relevant and required documents is also not illegal under Rwandan law.
I can read that.
You've subsequently had an opportunity to respond to Mr. Mugisha's report, first report, in your second and third witness statements. Yes?
Yes.
If we could have a look at your third witness statement, please. Paragraphs 21 and 22. And you again make assertions here that Rwanda violated on NRD's due process rights.
True.
And again, you do not cite any provisions of Rwandan law in support of your assertions about the violation of due process rights.
Yes, I did not.
And you didn't challenge in either of your second or third witness statements the conclusions in paragraphs 53 to 56 of Mr. Mugisha's report that there is no such law in Rwanda.
But I explained it. I explained, and I can explain due process as a concept. Due process as a legal principle is not necessarily, does not necessarily need to be codified, because these are legal requirements. It's reflected in the legal procedures, the legal requirements that are afforded to any citizen. In our case, afforded to NRD is right to the concessions.
I'm sorry, if I could just repeat my question. You did not challenge the conclusions of Mr. Mugisha in paragraphs 53 to 56 in either of your second or third witness statements, do you?
Can you put on screen the paragraph 53, please, of Mugisha's conclusion?
Operator, if we could just have 53 to 56 back up, please. And those paragraphs you did not challenge anywhere in your second or third witness statements, did you?
I think I challenged it in the several statements I made about the due process. The actions, the statements that were made by the ministry, the different officers in the Ministry of Natural Resources, the actions, the statements, and the letters that were being sent to NRD. I think we explained it.
Mr. I'm putting to you that you didn't challenge Mr. Mugisha's conclusion that there is no such law in Rwanda.
I have explained to you that due process does not necessarily need to be codified. You don't necessarily need to have a very specific, explicit clause in the law to say that this is due process. No, it's reflected in the legal procedures. It's reflected in the requirements that before you take away somebody's property, in our case, that person, that citizen, being an individual, a company, has to be given a minimum due process. The right to be heard, the right to know why that property is being taken away or infringed on, the right of response. And in this case, NRD waited almost 2 years to get a response. And that's,
Sorry.
That's why I, in my statement, I said there was lack of a minimum due process that was accorded to NRD, bearing in mind of the heavy investments that it had made during the 4 years.
You cited nothing at all in any of your statements regarding due process, did you?
Can you repeat the question, please?
You cited nothing at all in any of your witness statements about Rwandan law on due process.
I've explained to you, due process is a legal principle and it's a concept. You can see that through many laws. It doesn't necessarily have to be codified.
And that's because there is no Rwandan law imposing obligations in respect of due process, as you claim in your witness statements.
I think let me repeat it. Due process is reflected in various laws, including the 2008, 2014 law. For example, where they say that within 60 days, an application has to be made, and within I think 60 days, again in the law, the 2014 law, that a response has to be made to the applicant, and the reasons why they have to communicate the reasons why the license or the contract has been denied. That is, if it has been denied. But nothing was done in the case of NRD. They had to wait for more than a year, close to 2 years, to be told that unilaterally be told that your application was rejected.
No, we don't accept you cited any provisions, but I'm going to move on, and I'm going to ask you now about your background. If we could have operator, please could have exhibit R243. Page 7, please. This is your curriculum vitae, which you've submitted as part of your declaration.
Yes.
And if we can go to page 2 of the CV, please, operator. You set out your employment record.
Yes.
And prior to 2015, you worked in regulatory affairs for multinational companies outside of Rwanda in the period to 2007.
Yes.
And then in 2015, you say you started as managing partner at Legal Wise Chambers in Rwanda.
Sure.
And if we could go back to page 1 of the CV, please. You state you received your graduate diploma in legal practice in 2016.
Yes.
And that's a vocational course to be completed by those who want to qualify and practice as an attorney in Rwanda.
To practice as an attorney in the court of law, yeah. But you can you can be a consultant.
And
you're allowed to set up the law firm, but you cannot represent a client in court.
And you were admitted to the role of advocates in Rwanda on the 24th of October 2017.
Yes.
And when you made your first witness statement in February 2019, you've been admitted to the role for around 18 months.
I beg your pardon?
When you made your first witness statement in these proceedings in February 2019, you'd been admitted to the role in Rwanda for around 18 months.
Yes.
And when preparing your evidence, you've done so in the form of 3 witness statements.
Yes.
And you subsequently made a declaration which was made after you'd prepared your 3 witness statements.
Yes.
And if we could just go up to page 3 of the current exhibit, please, operator. And this is the declaration you made on the 18th of May 2020. And sorry, if we could just go on to the previous page. And in paragraph 2, you aver that you've complied with Article 5.2 of the IBA rules.
Yes.
And that included you making a declaration of your independence from the parties and their legal advisors.
Yes.
When making your witness statements, you did not provide any declaration as to your independence from the parties and their legal advisors.
I did not, because I was requested by the claimant to provide an assessment, to provide assistance as to whether his case, as to whether his situation, okay, will have a case in Rwanda, okay? And that's the reason why I came in as a witness statement. I acknowledge having signed a declaration, and this I accepted to sign it because when I received a counter expert report from Richard responding to my statement, he responded it as a lawyer. He raised legal issues, and as a lawyer, I thought that I could respond accordingly. But this issue never came up again as to whether I should be an expert witness.
And when you gave your witness statements, you were not instructed to act as an independent expert in these proceedings, were you?
No.
We looked a moment ago at your CV and employment background. And your employment record shows no evidence of you being an expert in the mining industry.
Is the witness still connected? Oh, you're still there. You vanished from our screen for a minute.
Mr. Ramaswamy, I think you're on mute.
Okay.
Did you hear my question, or would you like me to put it again?
Can you put it again, please?
I said on the basis of your employment record,
Yes.
that shows no evidence of you being an expert in the mining industry.
If you look at page 2 of my CV, I was the head of corporate regulatory affairs, Africa and Middle East, Vale, Mozambique. Vale is one of the top 5 mining companies, specializing in metals, specializing in coal. I was in charge of regulatory affairs, particularly in charge of negotiating concession agreements, mining concessions, railway concessions, ports concessions across Africa and Middle East. So I consider that I have expertise in mining, especially negotiation of licenses and contracts.
But that wasn't in Rwanda?
No.
You do not have any direct knowledge of the facts of this case, do you?
I was provided information from the claimant, sufficient documents, which I reviewed. using my knowledge of the mining sector. I consider that having had sufficient information on the case, sufficient facts on which I based my assessment and my witness statement.
You have no first-hand knowledge yourself.
Could you repeat that, please?
You have
Can you
no
repeat your question?
you have no first-hand knowledge yourself of the facts.
I've relied on the documents and the facts provided by the claimant.
And your knowledge is based on what you've been provided by the claimants and also your conversations with Mr. Marshall.
Of course, in working together with Mr. Marshall, I'll get back to him, interact with him and ask questions. It's very normal that I will speak to him and we'll have conversations. As a client, as someone who sought my assistance.
And in your witness statements, you've expressed various opinions on the facts, haven't you?
Again, I said on the basis of the facts and the documents I've reviewed, and on the basis of that, I express my opinion.
If we could have a look at some of the examples in your witness statements. Operator, please could we have Mr. Ramaswarago's third witness statement at paragraph 9? You say in paragraph 9, first sentence, that Rwanda has always acted as though the contract and licenses remained in effect.
Yes, I did.
If we could have a look at paragraph 10, please. You say that during the review process of NRD's reapplication, Rwanda acknowledged that NRD's contract and licenses remain valid.
Yes.
If we could have a look at paragraph 13, please. You say, based upon your review of the documents and evidence, NRD fulfilled its 5 contractual obligations.
Yes.
And these are all factual assertions which the tribunal can form their own view based on the evidence and having seen the witness's testimony.
Yes, yes. And I made those statements on the basis of the documents which had been submitted by the claimant, which had been provided to me. And I saw that they had met the requirements of the law. They had submitted the documents in time and in full.
And the preparation of the witness statements has not been your only role in relation to these proceedings.
What do you mean exactly, Mr. Daniel?
You've had a bigger role in this case than simply preparing your witness statements, haven't you?
No. My role was purely preparing a witness statement.
You've assisted in the preparation of the claimant's factual evidence.
Can you please repeat your question, Mr. Daniel?
You assisted in the preparation of the claimant's factual evidence.
I assisted the claimant in giving my assessment as to what the case will hold vis-a-vis in Rwanda. Yes.
You assisted in the preparation of Mr. Bidega's witness statements as well?
No.
Operator, if we could get up the transcript for day 5, please. If we could go to page 33. Mr. Cowley said on day 5 that you assisted in the preparation of Mr. Bidega's witness statement.
I would appreciate that he let him read the rest of what was said. We didn't discuss with this witness anything about this testimony. And
Mr. Cowley, if you could let the witness answer, please.
But this is not part of the witness, my witness statement. It's not part of the scope of my witness statement, Mr. Daniel.
But Mr. Cowley was right, was he, that you assisted in the preparation of Mr. Bidega's witness statement?
I said I did not participate in the preparation of the statement, and again, is out of the scope of my witness statement, Mr. Daniel.
So what Mr. Cowley says is wrong.
Again, I think this is greatly unfair when I want to explain the assistance that was provided. It's not being disclosed to this witness, yet he's asked to opine on it as to whether it's wrong without seeing it.
Operator, if I could get up CL020, please. And this is the 2008 mining law. If we could go to Article 118, which is on page 75 of the PDF. And this provided for the repeal of the decree of 1976 and the 1971 mining law.
Yes.
If we could have a look at Article 119. And this provided that the law came into force on the date in the publication of the Gazette. And if you look in the top right-hand corner, you can see that the Gazette was published on the 6th of April, 2009.
Yes, yes.
And this was after the licenses were granted to NRD in 2007.
Yes.
And so the relevant mining laws in place when NRD were granted the licenses was the 1971 law.
Yes.
Operator, please could we have CL002? And this is the 2014 mining law. If we could go to Article 52, which I think is on page 52. And these are transitional provisions under the 2014 mining law.
Mm-hmm. Yes.
And the first paragraph provided that any mineral license or quarry permit granted under the 2008 law on mining and exploitation shall remain in force until expiration of the period for which it was granted.
Yes.
And the licenses were granted under the 1971 law, so this paragraph was not applicable in respect of NRD's licenses.
Can you just go down to the paragraph 2? Just go down a bit.
I'm just focusing on paragraph 1, if that helps for the moment.
Okay.
And paragraph 1 is not applicable because it relates to licenses under the 2008 law, yes?
Yes, yes.
And the second paragraph provides that no mineral or quarry license granted prior to this law shall be extended or renewed. However, where the mineral or quarry license granted prior to this law provided for a right to apply for a renewal or extension of the license, the holder may be granted, subject to complying with this law, a similar type of license?
Yes.
And you've had chance to review the licenses which were granted to NRD as part of in preparing your witness statements?
As far as responding to expert Richard Mugisha's statement.
And none of the licenses granted in 2007 contained a right of renewal extension?
Yes, if you read Article 52, paragraph 1.
Sorry, my question was, none of the licenses granted to NRD in 2007 contained a right of renewal or extension?
It did.
Operator, if we could have a look at Exhibit C018. And this is the license granted to NRD in respect of Gotia. And if we could just scroll through the document, please. Into the English, please. Thank you. Just continue into the operative provisions, please. And you see Article 1. There's 3 pages. Sorry, you've gone past it. And Mr. Ramaswamy, I'm putting to you that in this document, there was no right of renewal or extension. Yes?
Yes.
And accordingly, the second paragraph of Article 52 did not apply either.
Yes, to that case, yeah.
Mr. Ramaswamy, I'd like to ask you about the arbitration between NRD and Mr. Benzinge.
Okay, yes.
And an arbitration award was made following a shareholder dispute between NRD and Mr. Benzinge.
Yes.
The dispute concerned the appointment of Mr. Marshall and Mrs. Moriskovikova to the board of NRD and the legality of the transfer of shares in NRD.
Yes.
And the arbitrator found the appointment of Ms. Moriskovica and Mr. Marshall were unlawful and they shall be dismissed as directors.
Yes.
And the arbitrator declared that the transfer of the shares to NRD Holding and HC Stark were illegal and null and void.
That's what the arbitrator declared.
And the consequence of the arbitrator's decision is that the legal shareholders of NRD reverted to being Mr. Benzinge and the Zarnaks.
That was the decision.
And the board reverted to the composition it had before the appointment of Ms. Moriskovikova and Mr. Marshall.
That would have been the implication of the ruling.
Operator, if we could get Exhibit R014. And this is the decision. This is the decision of the Rwandan High Court on NRD's appeal against the arbitrator's decision.
Yes.
If we could go to paragraph 10, please. The judgment records here that the ground of appeal was that NRD sought the annulment of the arbitrator's decision on the grounds that NRD had not been notified of the hearing.
Yes.
And if we could go to paragraph 17, please. And here the court ruled that the appeal failed because NRD had in fact been notified of the arbitrator's appointment.
Okay, yes.
And NRD had not started any procedures opposing her appointment as provided for under the Rwandan arbitration law.
I disagree with that. From the documents that I reviewed, to the best of my knowledge, from the documents provided by the claimant had objected to the arbitration center about the one of the arbitrators citing conflict of interest, but it was not acted upon.
Well, I'm putting to you, Mr. Ramasaraba, that that's not what the judgment says. And the judgment is clear. The findings included that the company did not start any procedures opposing her appointment as provided for in the arbitration law.
I've answered your question on the basis of the documents that were furnished to me by the claimant, which I saw reviewed, and having reviewed also the procedures.
And there's nothing in the judgment which says what you've just said.
I stand to my statement that I reviewed and I saw the claimant's notice objecting the appointment of the arbitrator before arbitration took place in accordance with the procedures.
Yes, Mr. Ramaswamy, I'm trying to concentrate on what the High Court found, and the High Court found that the company had not started any procedures opposing her appointment as provided in the arbitration law. That's right.
I do respect judgments. I do respect the independence of the arbitrator, but I also say that I have reviewed evidence. I've reviewed documents from the claimant objecting the appointment of the arbitrator, and on the basis of my assessment, the claimant had followed the required procedures in terms of objecting the appointment of the arbitrator.
If we could go to R015, please. This is the Supreme Court decision in respect of NRD's appeal.
Sure.
Please, could we go to paragraph 14? Paragraph 14 records that NRD were appealing on the basis that the procedure in the Articles of Association of the company had not been complied with, and only one arbitrator was appointed instead of 3.
Yes.
And those grounds of appeal were rejected by the Supreme Court.
Yes.
In your third witness statement, I can take you to the paragraph if you want, but as you've already mentioned it, you say that the arbitrator failed to disclose her relationship with Mr. Benzinge.
True.
If we could have a look at RM002, please. Article 14.2, please, page 20. And the second paragraph where the cursor is, an arbitrator may be challenged, please. Article 14.2 provides that an arbitrator may only be challenged if circumstances that exist give rise to justifiable reasons as to his or her impartiality or independence, or if he or she does not possess qualifications agreed to by the parties.
Yes.
Article 15, please, operator. This sets out the challenge procedure for disqualification of arbitrators. Yes.
Yes.
And the second paragraph provides that any challenge must be made within 7 days after becoming aware of the constitution of the tribunal or of any circumstances referred to in Article 14, paragraph 2.
Yes.
But NRD never made such a challenge at the time, and it's now too late for it to do so.
To the best of my knowledge, they made the objection in accordance with the required procedures.
The only challenges made are those recorded in the High Court and Supreme Court decisions.
But did you require an answer, please?
I said I've put to you that the challenges are those which were recorded in the High Court and Supreme Court decisions which we've looked at.
No, the claimant made the challenges also to the arbitration before the arbitration took place.
Please could we have Mr. Ramaswabo's first witness statement to paragraph 17? You say that the law in Rwanda is such that the RDB determines who is and who is not a shareholder of a company. The registrar's records on this matter are determinative shareholder ownership.
Yes.
You cite no provisions of Rwandan law in support of this statement.
I cited them somewhere in my statement.
In your first statement, and we can look at paragraph 17 without it being zoomed in, that you cite no provisions there of Rwandan law.
I did not cite, but in my other witness statements, it is cited.
There's nothing in the first statement. Yes.
Yes, it is not there.
If we could have a look at Mr. Ramaswabo's third witness statement, please. Paragraphs 33 and 34, please. You cite here Article 22 of the law governing companies.
Yes.
And at paragraph 34, you say that a certificate of incorporation from the RDB is conclusive evidence that the requirements of the law have been complied with. And
Yes.
a certificate of incorporation is conclusive evidence of and determinative that ownership of the company as set forth in the certificate has been lawfully established.
Yes.
And you don't cite any other provisions of Rwandan law in this statement in relation to this point.
No, I did not cite because Article 22 of the law governing companies mentions the certificate of incorporation as a conclusive evidence, which is evidence that the applicant company has satisfied the requirements of the law. Okay, so when you are issued this title, it is a right that is inviolable unless it has been issued contrary to the requirements of the law. So this article gives that weight that is equivalent to the right to private property right, basically. And that is why the legislator emphasized that it is a conclusive evidence.
Please could we have Mr. McGeish's second expert report, paragraphs 47 to 48. Sorry, Mr. McGeish's second expert report, please. And Mr. McGeisha responds here in relation to Article 22, and he explains that a certificate of incorporation is conclusive evidence that all the requirements of the company law in respect of incorporation have been complied with. Yes?
Yes, I disagree with his statement.
And the company has been duly incorporated under the company's law on the date of incorporation stated in the certificate.
Yes.
And you accept those statements are an accurate explanation of Article 22?
No, as explained by Mugisha, I think I've explained to you that Article 22 of the company law, I think you see the article there, clearly states in plain language that so long as the application and the Office of Registrar General, empowered by the law, examines the documents submitted, and once they have met the requirements of the law, complied with the requirements, then the certificate of incorporation is issued. And once it's issued, it becomes a conclusive evidence.
If we could have a look at paragraph 49. Mr. McGeisha says that the certificate of incorporation is conclusive only as to the fact of incorporation and the date of incorporation. And that's right, isn't it, on the plain words of Article 22?
No, it is not. I disagree with Mugisha's statement.
And if we could have a look at paragraph 50. And Mr. McGeisha says that in the first statement, first sentence, nowhere in the company's law is it provided that any records held by the registrar are conclusive evidence as to the ownership of the company. And you've not identified any such provisions, have you?
That is very wrong. That is very wrong. And Mugisha misinterprets Article 22 of the company law. And I think it's very clear that the company law says that the records that Mugisha is talking here is the paper, the documents that are required during application. So you have a series of documents that are required by the Registrar General. And once you submit these documents, which Mugisha calls records, once they have met the requirements, the law, then you are issued a certificate of incorporation, which is equivalent to a property right to the company or the individual. And I think Mugisha disregarded the spirit of the law, the intention of the legislator here. And there is a reason why the legislator says this should be a conclusive evidence, because it's a right to a property. And that right to property is the certificate of incorporation that gives you right to the shares that you hold. And that's why the law concludes and saying in Article 2, it is determinative of ownership of the company.
Mr. Ramaswamy, we don't accept that account, but I propose to move on. I'd like to ask you about what you say about the handover of the mining concessions. If we could have Mr. Ramaswamy's second witness statement, paragraph 5, please. Or paragraphs 5 to 10, please. In paragraphs 5 to 10, you set out what you say a formal handover process involves under Rwandan law.
Yeah, I mentioned on the regulations, the standard practice.
You refer to Articles 26 and 27 of the 2014 law and Article 6 of the 2015 law on investment protection.
Yes.
Operator, if we could get up CL002,
Yes,
the 2014 law. CL002, please. Article 26 and 27. Page 41, I think. Sorry, I think that's the index. Article 26 requires concession holders on cancellation of licenses to provide a full register of assets which the license holder intends to remove or leave in the mineral area.
Yes.
It also requires the concession holder to notify the minister of any potentially hazardous substances or excavations.
Yes.
Article 27, please. Article 27 requires the concession holder to deliver to the minister all records which the holder is obliged under the law to maintain.
Yes.
Articles 26 and 27 don't impose any obligations on the state.
Correct.
Please, could we have CL045? Page 13, Article 6. This provision protects private property rights under Rwandan law and prohibits expropriation of an investor's property.
Yes.
It does not contain any provisions relating to the handover of a mining concession?
Nope. But this was made with regard to protection of the investors' assets.
If we could have Mr. Ramaswarabo's second witness statement back, please. Paragraphs 5 to 10 again, please. And the provisions of Rwandan law which you cite there don't support the propositions you make in relation to a formal handover process, do they?
Again, as standard practice, a formal handover had to take place, and this had to be again facilitated by the ministry, because from the facts provided to me by the claimant and which I saw, they had no access to the offices, and some of their files had been confiscated. So from the facts and from the information provided by the claimant, there's no way that a handover could have taken place.
Mr. Ramaswara, you've cited no provisions of Rwandan law which support the propositions you make here, and that's because the handover process which you set out in your second witness statement doesn't exist under Rwandan law.
But there is, it doesn't exist, but the standard practice, and it's quite normal that such a big company in the large scale mining, been operating mining for 4 years, that you will just cancel a mining license without a proper handover. This, as a standard practice, as my experience in any mining, in the mining sector and where I've worked before, such handover process was a standard practice.
Thank you, Mr. Ramaswara. I have no further questions.
Yeah.
May I ask that RM7 be brought up? Is that the company law? Can I ask you to turn to
Yes.
can I ask you to turn to page 66? And it goes on to page 67. So yeah, no, if you leave it, Article 22 continues from page 66 to page 67. Mr. Ramaswara, you mentioned Article 22. Please explain what impact or effect this article has on the testimony of Mr. Magisha that was read to you and put to you by Attorney McCarthy, as you understand it.
My understanding of Article 22 is that first, the power to issue the certificate of incorporation is vested in the office of the Registrar General. And the law, including other requirements as set by the office of the Registrar General, highlights the requirements to be fulfilled by all applicants. Now, the office Registrar General, the office of the Registrar General examines the documents. And once these documents have satisfied the following, which are mentioned in article paragraph 2 and point 1, 2, and 3, once the application for registration has complied with the law, then the Registrar General does the following which I mentioned in paragraph 2, to register the application, register the matters relating to the company in the register of companies and business, and issue a certificate of incorporation. Within these 3, already even the owners, the shareholders have been determined on the basis of the information. So the office examines, including the minutes, appointing the directors, including the minutes, determining the share capital, including the minutes, appointing who is the chairman and what. So, and once they have satisfied the legal requirement, a certificate of incorporation is then issued. And here we have to look at the intention of the legislator. What was the spirit of the law? And here is the legislator wanted to make this like any other right to property, your right to the shares you hold in that company. And the reason why the legislator made it clear to say it is conclusive evidence that this application has complied with the law, and this Mugisha disregarded, and it has misinterpreted Article 22. And being conclusive evidence, it's also determinative of the ownership, because that ownership is included in the certificate of incorporation.
If I could ask that document C-144 now be brought up. Have you seen this document before, Mr. Ramaswamy?
Yes, I saw.
What do you understand this document to be?
This is an objection to the appointment of the arbitrator, Mrs. Nelly Omugwaneza. And the letter was requesting the investigation into the allegations made by the claimant, which were the conflict of interest of the arbitrator in the case.
No further questions.
Yeah. Thank you very much. Free to go now.
Yes, Mr. Ramaswamy, I have a question, which is this, that I'm looking at your first witness statement and in your second witness statement. And in both cases, I see.
Excuse me, Ms.
The witness bumped off. I'm trying to get him back on real quick. I'm sorry. I apologize. I didn't mean to interrupt, but I just want to let you know he is coming back in right now.
We have so little time. I hate it to waste time.
We're attempting to log in. The internet connection is very unstable there.
Well, maybe we should just proceed.
Mr. President, we may need to reach out and get in contact. Our system is offline, so.
Okay, look,
internet
it's not of. Yes, we don't need to bring him back. Yes. Yes, yes. Ms. Devon can ask Mr. Cowley to help with this.
Mr. Cowley, I was going to ask the witness the question, of course, but I'm sure you can help us as well. I'm looking at the first and the second witness statements of Mr. Ramasirabo, and I note that the signature page is entirely different from the rest of the document. Each of the reports had sufficient space on the last page to have the signature and its date appear there and the last sentence. But in fact, it's a signature page separately appended to the preceding statement in a different font. And I therefore ask whether the statement was in fact prepared for this witness by counsel to the claimant.
First, as to the appearance of it being in a different font, I think it's in a different size. I think that's as a result of the page that was sent back with the signature being a PDF or perhaps a picture that was static. So when we printed it out, it fills up much less than a full page itself. And so it's printed on a page as opposed to a different font. It prints in the right font, but the document itself is smaller than this page. That's just for the appearance of it. As I understand I'm looking at the first one. I don't have the second one open, and I'll take a look if there's a difference. But what I understand was in going back and forth with drafts, a final draft based on revisions, by Mr. Ramaswamy, who provided the testimony that we looked at, we made comments on, we asked him to send it back. We separated the last page just in case he could just send that one page back as opposed to the whole thing once he confirmed that the document that we were holding in our hands included every comment he made, anything he added or wanted changed. We drafted it for printing here in that sense, but this was what he told us. We did not purport to add on our own any substantive statement in here, if that's the basis of the question. We were typing up here what he told us in communications.
So when we read the sentence that I have prepared this witness statement with the assistance of counsel for the claimants, is that to tell us that it was simply production assistance?
Yes, we talked to him. We gave him, before this was finalized, we gave him anything he asked for, but there was some basic information, especially with the second. We had to ask him, because he would have no other access to it, the expert testimony of Mr. Mugisha. So we had to reach out to him and tell him what we wanted him to look at, ask him questions about what he could say, would say, and that's the assistance he's talking about. I cannot recall if he had a specific request for a document in the file that he didn't have from Mr. Marshall from his time. He met with Mr. Marshall, spoke with Mr. Marshall, had his own file on this matter before we ever talked to him about the first witness statement. I do not have a specific memory as to whether he asked us for something more from our case for the first statement. For the second, we had to give him almost everything that he was commenting on because he would have no other access to that.
Right. Thank you, Mr. Cowley.
Yes, shall we proceed, please, with the final witness?
Yes, we now have Mr. Mugisha.
Okay, we are bringing the witness in.
We have the witness declaration on the screen, not the expert.
So I wonder if FTI could.
Yep. Andrew, yep. The expert declaration, not the witness declaration, please. And the local folks are going to get the witness and put him in the chair, Mr. President.
Thank you.
Mr. Mugisha, can you hear us?
Yes, I can.
Okay, excellent. Okay, Mr. President.
Could you please look at the screen that's in front of you?
Yes.
And you see an expert declaration there?
Yes, I do.
If you're happy with it, would you please read it out?
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you.
Mr. Mugisha, I understand you're going to give a presentation to the tribunal in a moment. Is that right?
Yes, it is.
Good. So I will let you give your presentation. And then after that, Mr. Cowley, who represents the claimants, will ask you some questions.
Okay, thank you. Can I go to the next slide, please? I am a Rwandan lawyer with experience spanning over 20 years, having started as a government official in 1995 and being admitted to the bar in 2001 and setting up Trust Law Chambers, the law firm where I'm a partner, in 2004. I have been involved in a number of matters since becoming a private legal practitioner, including representing high-profile investors in the country, including in the mining sector. I've also been privileged to having chaired the Business Law Reform Commission between the years 2005 and 2007. Next slide, please. This is going to be an overview of the key aspects of my expert report. And I'll begin with my interpretation of the contract for the acquisition of mining concession and mining license. I've reviewed the contract and it imposes obligations on NRD in Article 2 as the making of geographical demarcations of perimeters, providing an action plan, an environmental action plan, and an investment plan, and to proceed immediately to industrial exploitation. 4, provide progress reports on research after 2 years. And finally, to provide progress reports on reserves and feasibility after 4 years. In the same contract under Article 4, there is a provision for the evaluation of the feasibility study on the basis of which, if evaluated positively, would trigger the granting of a long-term concession. The granting of the concession is dependent on the performance of the obligations stipulated in Article 2, and therefore are suspensive conditions in accordance with Articles 77 and 78 of the contract law applicable in Rwanda. I have noted the assertion that in order for these conditions to be deemed suspensive, there had to be the language suspensive condition stipulated in the agreements. I disagree on the basis that the language is plain, clear, and straightforward that these were suspensive conditions. Next slide, please. Next slide. Sorry, can you go back to the slide before? Thank you. I understand that the NRD feasibility study was found unsatisfactory, and therefore there couldn't have been an obligation to grant a long-term concession. I have also noted that there's been an assertion that each time the licenses were extended, that made it an automatic renewal of the contract which provided the framework for the licenses. This is inaccurate because the mining rights are derived from the licenses, and the contract is independent of the license. It simply provides a framework on the basis of which licenses will be issued. There's also been an assertion that the failure to advise NRD of the criteria for the assessment of the feasibility study makes it a failure on the administrative discretion of the minister. I disagree because the contract does not have any criteria for the assessment of the feasibility study, which therefore means that the feasibility study was within the absolute discretion of the minister. I have also noted that there's an assertion that the failure to provide reasons why the feasibility study was not deemed satisfactory does invalidate the decision. Again, I do not agree with this assertion because there's no legal basis for it. Throughout through my review of the documents, I noted that there was a concern about the failure to adhere to Rwanda's due process. Now, just to make it clear here, and as is the case with most civil law jurisdictions, there is no such a thing as a law on due process. What does happen is that sector-specific legislations will provide for a framework under which any administrative actions are taken. Where sector-specific legislation doesn't provide for that, there is a procedure in the Code of Civil, Commercial, Administrative, and Labor Law under which dissatisfied members of the public can seek recourse from the court of law. So again, just to emphasize, there's no such a thing as a code on due process. Next slide. I'll now turn on the framework for mining in the country as it applies to the matter before the tribunal. There's been an assertion that the NRD concessions were grandfathered by Article 252 of the 2014 law, which provided that all concessions granted under the 2008 legislation would be grandfathered. My opinion is that this cannot apply to the NRD licenses, which were granted in 2007, pursuant to the 1971 legislation. In addition, they did not provide for an automatic right of renewal or extension. I have noted that there were a number of extensions granted to NRD up to October 2012. My opinion is that the extensions authorizations were not a contractual obligation, but only a courtesy extended to allow for better preparation for negotiation of new licenses. And again, such a practice is not entirely unusual and is done as a good faith gesture to facilitate applicants who would require that kind of time. These were indeed, as I said, courtesy gestures which could be revoked at any time if the government deemed it appropriate. There's also been an assertion that the requirement for NRD to reapply for licenses was a breach of the law. I disagree because there's no contractual basis for making such an assertion. In fact, reapplication was rather a requirement of the law. Next slide. With respect to the legal effects of the arbitral award and the court decisions thereof, I looked at the award as well as the court decisions, and I noted that Mr. Benzinge challenged, brought an arbitral award, or an arbitral claim for which challenged the transfer of shares to NRD and HC Stack, the appointment of Mr. Marshall as managing director, the appointment of Mr. Marshall and Mrs. Moroskova to the board of NRD. The arbitrator found these three decisions unlawful and rendered them ab initio. Next slide. Next slide. NRD did challenge. Can you please go back to the previous slide? NRD challenged the award in the High Court and sought its annulment, alleging that the procedure in the articles of NRD was not followed and NRD was not notified of the arbitration proceedings. The High Court found the arbitration proceedings had followed all the requirements of the law and upheld the award. NRD appealed to the Supreme Court on the same grounds, and the Supreme Court upheld the High Court decision and confirmed the arbitral award. It is important here to note that the courts in Rwanda have taken a very strict approach when it comes to arbitration proceedings, and taken the view that the involvement of the court would only be to the extent of supporting the implementation of the arbitration agreement. And so there is a very narrow window for challenging arbitration decisions, and it is provided in Article 47 of the Law on Arbitration and Conciliation of 2008. It doesn't therefore surprise me that these decisions took the approach they did. Having said that, in accordance with the Constitution of the Republic of Rwanda in Article 151, which provides that court rulings are binding on all parties concerned, be they public authorities or individuals, and that they cannot be challenged except through procedures determined by the law, it follows that the shares in RD reverted to both Ben Benzinge and the Xanax. Next and final slide, I guess. Yeah, I note that there's been an assertion that there is a handover process provided for by the law, which was not followed when the licenses were, when the handover of the concessions should have been done. Here, I have to say that I'm not aware of any legislation, regulation, or guidance setting out formal handover processes. And throughout my time as a practitioner, I've never had to attend to any of these. What I do know is that the law does impose obligations on existing concession holders, and mainly this is to do with making good the concession areas so that whatever environmental damage could have been occasioned on the locations can be made good. There are no corresponding obligations to this on the states that I know of in any legislation. Thank you very much for your attention.
Have a break now. Break. Do you take the break now?
That's very good.
Yes. Yes. I think it'd be a good idea if we take the half-hour break now. Could I just say this to counsel? The role of an expert evidence on foreign law is to inform the tribunal of the law. It's not to inform the tribunal of the answer applying the law. Almost inevitably, it's very, very difficult for expert witnesses to distinguish between the two. But when cross-examining Mr. Cowley, bear in mind that the decision of the effect of Rwandan law is for us. The question of what Rwandan law is one of expert evidence that we have to resolve on the evidence. Do you follow the distinction?
I will do my best to get it into heart.
It is hard. It is hard.
I do not have in the expectation or the intention of asking the ultimate question that you are being posed with and challenging Mr. Mugisha with it. That's not my intent. I have some specific questions about his reports, and I will do my best during the break to make sure I'm complying with your expectations.
Very well. We will adjourn for half an hour.
Okay, we're going to open the breakout rooms right now.
Members of the tribunal, we are ready to resume. When you are ready, I note that your connection is on mute.
Right, can you hear me?
Yes.
All right, let us resume.
Thank you for your patience, everybody.
Okay, we'll bring the witness back in.
Yes, please.
Mr. Magusha, I know you may be standing in the room. Can you please take your seat?
To chair.
He may have just stepped out. I'm going to call the contact in the IT contact, Mr. President. We'll get him right back in the seat.
Thank you. Carly, you have the witness.
Thank you, Your Honor. Mr. Mugisha, good afternoon. It may be evening your time. Can I ask that the second expert report of Mr. Mugisha be brought up and focus on paragraph 17? Is this the May 27, 2020 report? Yes, it is. Thank you. Mr. Mugisha, paragraph 17 talks about what is, and I'll ask if it could be brought up and put side by side. In paragraph, excuse me, in the contract, that's C17 as a document number, Article 4, correct? And bring it up and show you. Your paragraph 17 is talking in part about your opinion regarding that paragraph, correct? That article, excuse me.
It's talking in general terms about how decisions of government are taken.
And because your expert report goes on to apply the law as you describe it to Article 4, correct?
Can you say that again?
Your report goes on to apply what you're describing as Rwandan law in paragraph 17 to Article 4, correct?
That's correct.
And you'll agree there's no other provision in the contract that we need to look at that you believe constitutes an agreement in the contract as to how a positive evaluation of a submitted feasibility study is to be interpreted, correct?
There's none that I've seen.
Now, if I could ask that two documents be brought up, R111 and C32. For R111, I could ask you to highlight the second paragraph. And for C32, the first paragraph has a third sentence. That's fine. Leave that whole thing so you could read what the context is. Now, I'm going to tell you that if that these both were attributed by Dr. Mike Ramba. I'm sure I mispronounced that. I apologize to him in his absence. But who we've been referring to as Dr. Mike testified that both of these documents were his. He authored. If I could ask that now, contract law, Article 67, the contract law document is RM001. And Article 67 be brought up, please. Which is on page 45. Now, Mr. Mugisha, I'll go back through it slower if necessary, because you can only put up so much at one time. I don't want to make this an exercise in short-term memory, but if the tribunal were to find that Dr. Mike is one of or the representative of the respondent responsible for interpreting Article 4 of the contract when making the assessment that's referred to there, and if the tribunal were to find that the plaintiffs agree with Dr. Mike's interpretation of that provision, you'll agree that Article 67's first paragraph then applies, correct?
Yes.
And even if those two preliminary findings are not made by the tribunal, will you agree, sir, that Article 67, if we could scroll up, Article 66, I'm sorry, I didn't mean to repeat 67. Article 66 of the contract law applies in any event to any interpretation of a clause or provision in a contract, correct?
Well, Article 66 is very clear, yeah, in the sense that it refers to the intent of the contract at the time of its signature.
I'll ask the question again. I'm not sure if you're done answering. I don't mean to speak over you if you are still trying to answer, but if you've completed your answer, my question again is, regardless of whether or not the tribunal makes the determination, the factual determinations that I premised my last question on regarding Article 67, if they do not make those determinations, Article 66 does apply to any interpretation of the contract that the tribunal is to make as it applies concerning Article 4 of the contract, correct?
Can you say that again?
Yes. If Article 67 is determined by the tribunal not to control, well, then Article 66 of the contract law does apply to whatever interpretation the tribunal makes of Article 4 of the party's contract, correct?
I still don't understand your question. Can you go over that again?
Yes. In the event the tribunal does not determine facts such that Article 67 is determinative, we talked about Article 67. My premise of this question is just, if the tribunal determines that doesn't apply, well, then Article 6 does apply to whatever interpretation the tribunal is to give to the contract's Article 4, correct?
Read together with Article 2.
And Article 69 of the contract law, correct?
Mm-hmm.
Sorry. Principles of interpretation. And that's on page 47, if they could be brought up. I see that it wasn't brought up. I think that's what I was being asked to look at. So in RM1, page 47. Are you done reading, sir?
Yes,
So in the event that the tribunal does not determine that Article 67 of the contract law is determinative, then in addition to Article 2, Article 66, also Article 69 of the contract law applies to any interpretation that should be made of the party's contract at Article 4, correct?
that's correct. Only that where the clauses are explicit, then that is what takes precedence.
If I could ask that the first report be brought up. And if we could go to, I believe it's the last substantive paragraph. Yes, page 15, paragraph 58. And if we could put that testimony to the left, raise it up again so we could read his own language again. I apologize. I seem to have crossed off the reference to the document I want to bring up. Give me one moment. I made some edits during the break, and I made an edit that shouldn't have been made. My apologies, I've reoriented. If we could leave that paragraph 58 highlighted up and also go back to paragraph 18 in the same report and highlight that paragraph and show them together. Have you read those, sir?
Yes, I have.
Okay, so the principle you identify in paragraph 58, that the public minds revert to the government of Rwanda when the license expires. Is it your opinion that that principle applies during the gaps between the written extensions of the license agreement, of NRD's license agreement that expired at the beginning of 2011?
Can you say that again?
Yes, you see in paragraph 18 of your witness statement, you talk about short-term licenses.
Yes.
And the other principles that you were talking about, you say what effect you believe the short-term licenses has, which is none on your prior principles. But I want to focus you on the dates, the extensions cover, and referencing those gaps that show in the written extensions. Is it your opinion that you're giving to the tribunal that the principle announced in 58 about reversion to the government of Rwanda, does that apply to the gap period in between the first and second extension?
Obviously, as long as there is no express extension, the principle applies.
So your opinion to the tribunal is the principle in paragraph 58 applied when the first written extension expired without another written extension being provided?
That's correct.
And then you note in paragraph 18 that a second extension was provided in writing with a gap period not covered. But what is your opinion that you're expressing to that tribunal about the principle in paragraph 58? Does it now no longer apply?
I don't understand where you're getting with this. I've said that a duration of the extension is what it is, and the principle does apply.
So 6 months after August 2nd, 2011, the mining concessions reverted to Rwanda as government property. That principle in paragraph 58 you're saying applies at that date, correct?
Yes.
So what principle do you identify in your report permits Rwanda to grant the second extension after the mining concessions had reverted to it? Is there anything in your report that identifies the authority of the government to grant a license to only one party for a mining concession without making it publicly available for competitive bid?
Of course. That's the discretion of government.
So it's your testimony that under Rwandan law, the government of Rwanda has discretion to license or otherwise transfer government property to one party without making it publicly available for competitive bid?
There are two ways in which this can happen. One would be by way of a competitive bid. The other is where unsolicited proposals are presented to government. In either of the cases, the government does take a decision.
You are aware that there are public tender principles under Rwandan law with regard limiting the government and its agencies' ability to transfer government property, correct?
I'm not aware of those laws.
So is it your testimony that no such law applies to the government of Rwanda in this case? They're not required to put out any public tender for the transfer of mining licenses or mining concessions. That's your testimony?
That's correct.
And forgetting the gap period now in between the three written extensions that you reference in paragraph 18, it's your testimony to the tribunal that the principle identified in paragraph 58 applied again at the end of the 1 month extension of a license to NRD that began on September 13, 2012?
That's correct.
And is it your testimony to the tribunal that that same principle equally applies to all other applicants for concessions who had requests for licenses or long-term licenses, I should say, to concessions still being discussed when a last written extension of their original license expired?
Well, I'm not aware of such cases, so
I could ask a simpler question than I should have. The principle you just identified as applying as of October 13, 2012 to the NRD licenses equally applies to all other long-term concession applicants, correct?
That's right.
If there are any.
Yes.
If I could ask now that these documents can be closed, if I could ask that the arbitration award R13 be brought up. You gave testimony in your witness statements about the Ben Benzingi dispute with NRD, correct?
That's right.
Including testimony about the effect of the arbitration award between Ben Benzingi and NRD, correct?
Yes, that's right.
If I could ask that page 4 be brought up.
What number is the award?
Page 4.
What number? Sorry, what number? The award.
R13, Mr. President.
Thank you.
Now, in your testimony, you talk about the reversion based on the arbitrator's award. You say there's a principle of reversion that applies, and then you give your conclusion as to what the effect of such principle is on the various shareholder actions that were subject to the award. I'd like to draw your attention to the first paragraph, where it says in the, I believe it should be the second sentence. It's after the word entitled. I don't see a period there, but I believe that's a first sentence. And then the full registration starts a second sentence, at least as best I can tell. Can you highlight the whole sentence? You see in the arbitration award, it's the arbitrator set out what she found in the RDB's corporate files as submitted to her, included a full registration information, domestic company document issued by that institution, the RDB, states that the last amendment was made on 2 August 12, and it shows Mr. Roderick Marshall was the company representative.
Yes, I've read it.
Whereas Mr. Benzingi was the managing director. Do you see that?
Mhm.
Is that a yes? You
Yes.
understand what paragraph I'm talking? And you talk about this principle of reversion and you refer to that sentence. Do you see that? Do you agree with that? Excuse me?
I don't refer to that sentence. I refer to the entire award.
Right, but you refer to the reference to Mr. Benzingi as managing director when you refer to the principle of reversion. Is that correct?
I talked about the shareholders. The shares reverting, not who is the official.
I didn't catch the last word. Not who is what?
I talked about the reversion of shares going back to Mr. Benzingi and the Xanax.
Paragraph 46. I ask that the first report be brought up and paragraph 46 highlighted. in this paragraph, you talk about the application of the reversion principle as a result of the arbitration decision, correct?
That's right.
Okay, and my previous request was in terms of bringing up the arbitration award itself, if we could put it side by side, R13. And page 4, the first paragraph. Based on your explanation of the reversion principle that you say applies to the arbitrator's decision nullifying certain actions, it applies equally to the record in the RDB in both the first and second sentences. So both the reference to the record, including Mr. Benzingi as managing director and Mr. Marshall as representative, and the prior sentence talking about on August 6, 2012, the action of suspending Mr. Benzingi as managing director. The reversion principle you announced applies to both documents in the RDB's files, correct?
I am just reading the conclusions of the award and just inferring what they are about. I have not gone into the analysis of the award as you would like me to.
I'm not asking you to do an analysis. I'm asking you to explain the reversion principle. You refer to certain prior findings in the or prior statements about the parties' positions.
I'm only saying that following the award, the effect was that. That's it.
And that the reason for the opinion you give about the effect, I'm simply asking you to clarify. That same reasoning applies to the other documents in the RDB's files regarding the party's status, not just one, but the full file as to the party's respective status get the benefit of this reversion principle, correct?
Look, I've told you what the conclusions of the award are and the effect they have.
Do you agree with me, sir, that the reversion principle that you rely on applies to both of the documents that are referenced in the first paragraph on page 4 of the arbitration award?
It should.
Same law applies. Right?
Yes.
I could ask now that C0005 as company law be brought up and focus on Article 22. RM7. And so it's, sorry, is it not stop? I can't see, I can't see that small ray. Is that? Nope. Let's see. It would help, I'm sure. Page 66. Okay. And thank you for Article 22. If on the left, the document that I brought up, can Mr. McGee show what the document consists of? So
Yeah, so what's your question?
if you could go back up, I believe it's the second page. I don't have the document in hand, so I'm relying on small, the date on it, the date of the document. Yes, it does. So I want to make sure you're aware of the date that this document that was transmitted by the cover letter, but the date of the actual document that's being referred to is July 3, 2004. To the Article 12 company law, the RDB's full registration information for domestic company report when it was issued on 14, correct?
Article 20 about took place on 3rd July 2014 is an amendment to the information
Article 22 of the company law applies to the RDB's action that's titled Full Registration Information for Domestic Company, company name Natural Resources Development Rwanda Limited, on July 3, 2014, correct?
That is not the date of incorporation. That is the date of the last amendment. Can you look at it?
Is it your testimony that Article 22 does not apply to the document issued by the RDB on July 3, 2014?
July 3rd July 2014 is an amendment. Just like the date was clear. Article 22 is about the because it's actually an article about incorporation of a company. When does the company?
So I'm trying to focus the question on whether it's your testimony to the tribunal that in determining the import of document that's C5, that's the left of the screen. They are to look to the
law about that is provided at the time of incorporation and the information that is for purposes of incorporation. Now, the document on the left-hand side of the screen the is information that provides records information provides a record as any other record.
Not apply Article 25. Perhaps it would be a good idea, Mr. Clive.
Okay. Mr. Magishu, is it your testimony to the tribunal 5,000? Say that. I didn't hear what you said. Yes, you said, or something else?
Yes.
Is that right? That's dealing with an amendment to the company's name. I think the point you're making is we're dealing with an amendment to the registry, not with the
Yes.
original certification. Article 25 deals with an amendment to the name. Is there any article that deals with an amendment to the representation of the company?
There's no article that deals with the amendment of the information at the date of incorporation, but there are articles. On the top of my head, I can think of Article 212, which obliges the registrar to amend the registry on the basis of information provided from time to time.
I did not catch that number. Please say it again.
I think it's 212.
I'm told that that's on page 265. If the controller can bring that up, please. That the provision you were referring to?
The registrar to update the registry.
For corporations that are registered, what a change in shareholders or directors or managing director appointment?
It is the office of the Registrar General.
Is there any question that in your testimony, is there any question that Rwandan law requires corporations registered in Rwanda to make those reports to the Registrar General?
There is, yes, there's an obligation to file those returns.
And that obligation applies only to the Registrar General and to no one else, correct?
That's correct.
If I could ask that the document C186 be brought up. Mr. Mugisha, C-186 is a May 22nd, 2008 letter from one of your colleagues at your firm, Mr. Apollo, I believe, under the stamp. And it's discussing the transaction relating to the Zarnax, excuse me, it's discussing a transaction relating to the Zarnax percentage interest in NRD holding GmbH. Do you see that?
Yes, that's right.
And that entity, NRD Holdings GmbH, you understood was the holding company that owned NRD Rwanda Limited, correct?
Yeah,
And,
it's clear on the face of this.
and your firm represented the Zarnax, the majority shareholders in NRD Rwanda Limited, in connection with the transaction that's discussed here, correct?
That's correct.
And the other shareholder, the minority shareholder in NRD Rwanda Limited was Ben Benzingi at the time, correct?
That's correct.
If I could ask that, if that be left up on the left, but if I could ask that the witness statement, respondent's witness statement of Jean Bosco Insigiamu. I mispronounce it every time I talk to him, and I apologize in his absence for mispronouncing it again. And bring it to paragraph 20. If I could ask you to highlight the second to last sentence, I sent a demand letter to Mr. Benzingi. Can you highlight that whole sentence? Do you agree with Bailiff Bosco's statement of Rwanda law in paragraph 20 of his witness statement that shareholders in NRD are liable for its debts?
I do not.
It's your testimony to the tribunal that Bailiff Bosco misstated the applicable Rwandan law to the principle of whether or not shareholders of the company are liable for its debts?
He gave oral evidence that in Rwandan law, shareholders are not liable. Bosco clearly said that.
Yes, our recollection is that Mr. Bosco, we may call him that, stated firmly that shareholders were not liable for the debt of the company.
Yeah.
It's claimant's position, and I don't contest the tribunal's recollection of one of Mr. Bosco's statements on the subject. It's claimant's position that in a different part of his testimony, he confirmed this representation in his witness statement as to a different action, as to why he served a certain letter on Mr. Benzingi, and the testimony that you're recollecting related to whether or not he agreed that a car he was seizing was Mr. Marshall's personal car or not. And so I would suggest, I can't quote the transcript. I would just suggest the reason I'm asking this is because I thought there was a basis from his live testimony that he confirmed his principle.
I don't
once.
recall that there's any basis for it, and my recollections is exactly the same as the tribunal's. He was very clear in his testimony that shareholders are not liable for the debts of the company.
No, it was very clear,
Yes,
definitely.
I have a recollection, I think, that accords with Mr. Conway's, Mr. Cowley, that earlier, before he made that very clear statement, he had suggested that a shareholder might be liable for the company's debt. But certainly I took him as making a quite clear correction to that statement. Anyway, if they're conflicting statements, he's made their conflicting statements.
Yes, and I think that the purpose of bringing it up to show it to him was has already been served. I asked the question as to what his testimony was, and he's given it. So I wasn't going to press the issue further with the statement.
Mr. Conway, since we are on a particular document right now, it may save time if I can ask a question of Mr. Mugisha. Mr. Mugisha, looking at the document of the 22nd of May, 2008, it talks about the transfer of the shares upon payment of the price. What is the effect of non-payment of the price in relation to the transfer, if any? Is the transfer valid anyway and there's a debt, or is there no valid transfer? Can you help us on that?
It would depend on the underlying agreements for the transaction.
Thank you.
If I could ask that the first report be brought up. And highlight paragraph 47, please. Mr. Mugisha, you say you give testimony here about the consequence of both the arbitration award as upheld by the Supreme Court, and you state the circumstances were that the Zarnaks no longer wish to exercise authority over the company. To what do you cite for the principle that it's been established as to the Zarnaks' position with regard to whatever interest they may wish to assert in NRD in light of the arbitration award?
Let me give some context to this statement. And the context is this. Following the judgment, the arbitration award and its confirmation by the Supreme Court, everybody was entitled to deal with either the Zarnaks or Mr. Benzinge on matters related to NRD. And in the event that the Zarnaks were not able to do so, there should have been no vacuum as long as Mr. Benzinge was available. And the reason I say this is that under Rwandan law, especially the Constitution of the Republic of Rwanda, Article 151, every individual or public authority is obliged to respect court decisions and only challenge them through procedures determined by the law. Now, with such a decision having come from the Supreme Court, it is obvious that no vacuum was expected to be at the company. So this is the context to this statement.
I'm sorry, that last part I missed. What was the context of the statement, that last part? No, you said it was obvious that nobody what?
That in the absence of the Zarnaks, Mr. Benzinge could act on behalf of the company and everyone else was entitled to treat him as acting for the company.
Well, Thank you. Are you done?
Yes, I am.
Okay, I appreciate your explanation, but I'm still troubled by trying to understand why is it that you're making a representation in paragraph 47 that the Zarnaks no longer wish to exercise authority over the company? What was your source of information? What was the source of your testimony as to the Zarnaks' stated desire or lack of desire on that topic?
Look, as I said, when I was requested to provide an expert report, I was availed with documentation. So obviously I know the facts of the case. And that is what was at the back of my mind when I made that statement.
It's now closed, but we looked at a letter in which you were representing the Zarnaks.
If we're going away from this, I'm very anxious not to spend a very long time chasing red herrings. You have qualified your statement in paragraph 47 by the words, in circumstances where the Zarnaks no longer wish to exercise authority, and the dispute is between Mr. Marshall and Mr. Benzingi. If one struck out all of that, would your statement be accurate?
Sorry, sir, can you repeat the sentence?
If you put a line through paragraph 47,
Yes.
beginning at the last word of the first line, and ending before it is Mr. Benzingi. So the statement read, as a consequence of the arbitration award as upheld by the Supreme Court, it is Mr. Benzingi who would have authority to act on behalf of the company. Would that be accurate?
Yes.
It would.
Yeah.
That is in conflict with the document produced by the registry on the 3rd of July 2014 that we have just looked at, C005.
Yes, and like I explained, pursuant to Article 151 of the Constitution of the Republic of Rwanda, the registry would have no choice but to update the registry accordingly.
So does it look as though something must have happened between the time of that award and the 3rd of July 2014 that resulted in the registrar making the record that he did?
I'm not privy to what certainly did happen. All I'm saying is that if the award had been presented, the registry was entitled to record the contents of the award, i.e. to say that the status quo before the transfer of shares was done should revert.
Yes.
I don't see.
It may help with this questioning if we bring up the Supreme Court's decision so the date of that can be looked at compared to the registrar's action. So there's no confusion as to which came first and which came second.
Well, what is the date of the Supreme Court decision?
It is May 2nd, 2014, and the document number is R15EN. Should be up at the top in the bold section at the very top caption. Hard for me to read. At the very top, there you go.
Mr. Hill, this arbitration has proceeded on the basis, as I understand it, that the amended registration or the particulars in that amended registration of the 3rd of July 2014 were correct, i.e. that Mr. Marshall has authority to act for the company.
Well, in this arbitration, Mr. Marshall is acting on behalf of the claimants. I mean, NRD isn't a party.
Yes.
So in terms of representing NRD in the arbitration, NRD doesn't have a role in the arbitration.
No, that's true. But if Mr. Marshall has authority to act for the company, it can only be through Spalena.
Yes, but as I say, it doesn't arise because in the arbitration, NRD is not a party.
Mr. Hill, we follow that
Yes, I'm sorry. I'm being
the company into which the investment was made is not a party under the BIT, and in this arbitration, we follow that very well. But what is the position with Spalena, you see? Because they were meant to be the people who acquired the shares. And it's very confusing. At the moment, it doesn't seem to us to have been resolved with clarity as to who exactly is the shareholder as a result of this arbitration award, or are the shareholders? And where is Spalena in all of this?
Yes, well, as you've heard from Mr. McGeish's evidence, his view, and it's at 45 as well as 47 of his witness statement, is that the effect of the award is that the transfers of shareholdings are nullified. The result being that there's a reversion to the original shareholders, who are the Zarnaks and Benzingi. And that's why he says in circumstances where the Zarnaks are not on the scene, Benzingi can have authority. But obviously if the Zarnaks were on the scene, the shareholdings will have reverted to them and they could take actions as shareholders. So that's his view.
Yes. Can I raise the difficulty I have with all of this? The arbitration was based upon, as I understand it, an arbitration agreement between the original shareholders who formed the company. And as it seems to me, it's an arbitration agreement which would apply as in relation to a dispute between shareholders. The arbitration purports to have been between the company on the one side and Mr. Benzingi on the other. And I have great difficulty in seeing how the arbitration agreement could result in such an arbitration as opposed to an inter-shareholder arbitration. And B, I have difficulty seeing how the result of the arbitration could operate in rem so as to divorce Spalena from its shareholding.
Yes,
those are the difficulties I have.
Yes, I mean, I wonder whether rather than trying to tackle all those on the hoof, I could digest those, and it may be points that we can pick up in closing. I understand the difficulties.
Yes.
I'm not sure how much those difficulties are central to any issues that you're actually deciding, and that's perhaps something that I'd like to consider and address.
Well,
because our standing point is it hasn't been put forward at the centre of our standing point.
No.
And where it does arise is in relation to the reasonableness of the actions, in particular of Mr. Immoner, who considered he was caught between two people with different assertions. And unless it's being said that it should somehow have been obvious to Mr. Immoner that he could in some way disregard the Supreme Court award, I'm not sure the point really matters that much to anything the tribunal is in fact is actually deciding.
Well, that's
I
precisely,
think that's right. But,
that's precisely our point as of July 4, 2014. That's why we've raised that. It couldn't be in doubt as of the day that registrar's statement was
No,
available.
I certainly don't accept that. I certainly don't accept that anything couldn't be in doubt. There is plainly, as Mr. McGeisha explains, a natural consequence of the award and the Supreme Court judgment on it that to the reader, at any rate, has that consequence, and to in such that Mr. Immoner for example, would have been acting entirely reasonably in taking the position that he did.
If I was permitted to finish my sentence, what I was trying to say was, it certainly couldn't be in doubt what instruction Mr. Emina was required to follow as of July 4, 2014.
But we don't accept that either.
As it may be to him, the registrar has spoken. No action was pending as of July 4, 2014 to challenge it. None is pending now that we've been informed of. But the point was, as of a certain date, our point has been, as of a certain date, he was required to follow the law and let the registrar who has spoken speak and have effect.
And we don't accept that for a moment, because we don't accept the conclusiveness that Mr. Cowley asserts of the registrar, and anything in the register could be open to challenge. And Mr. Benzingi was armed with the material prima facie to challenge it.
I was speaking to our position because that's what you asked in rhetorical form, albeit, but it wasn't a joke. It shouldn't have been rhetorical. That was our very position. The reason I spoke about it is because that's how you phrased it. If you asked if the position was.
Can we come back to the fundamental point, which is worrying me, and that is that when this arbitration began, and on day one, I understood it to be common ground that Spalena was the ultimate holding company of NRD. And that's the basis upon which we've been proceeding. And if that's not correct, there's a very short answer to Spalena's claim.
It's the basis we've been proceeding as well. We thought it was an agreed fact before the hearings started.
I currently would be inclined to proceed on the basis that it's very hard to understand precisely the nature and effect of this arbitration award, but that we would proceed on the common ground that by the 3rd of July 2014, the position was, as stated by the registrar, and as we understand it, has remained the position on the registry ever since. Well, that's my current approach.
Can we consider that? Well,
Yes.
we do. I mean, even were we to accept that as a working way forward, I would just want to stress that we certainly wouldn't be accepting that it follows from that, but it would have been obvious, say, to Mr. Imina, that Mr. Benzingi was wrong to be brandishing a Supreme Court award at him, and Mr. Imina was in some way required to ignore Mr. Benzingi. So there's a slightly different nuance. But I'd want to be clear that any acceptance of us of that as a way forward doesn't carry with it the acceptance of Mr. Cowley's proposition.
So far as I'm concerned, that strikes me as perfectly fair.
So far as I'm concerned, Mr. Imina can have acted in good faith, there being conflicting positions taken, and he then proceeded in a careful manner. That's one way of seeing it.
Rather than argue it now, please just note our position is we have more to point to in Mr. Imina's testimony, both in his witness statements and live at the hearings, that support our position that he knew exactly what he was supposed to do. And he actually said he was doing it. Meanwhile, we say the record was contrary. But we'll pick up this point, both of us, in the closing. At the risk of belaboring a point that you think is over, I actually had a different purpose in trying to address a couple of questions to Mr. Mugisha on this topic. And so for clarity's sake, and to avoid frustrating everybody that you think I'm perpetuating an issue that we've now talked through, to be clear, the claimants remained very concerned that Mr. Mugisha, as far as the records has shown so far, his firm and Mr. Mugisha's personal representation are in conflict, because the only, certainly the last known representative of the Zarnaks in Rwanda who could inform them, give them notice, talk to them about what interest they may have in reasserting control over NRD and doing another transaction like clarifying the shareholdings or not, but the advice from a lawyer, that lawyer would be Mr. Mugisha or his firm. And at the same time, the respondent has an interest in continuing to breathe life into Mr. Benzingi's, how should I call it? Efforts to confuse the situation thoroughly, because the respondents believe they benefit from lingering confusion about his status and the status of the shareholding, which relies, at least very much in part, on Mr. Magisha's testimony about how the arbitration award and the decision upholding it must be interpreted under Rwanda law. We see a very clear, at least potential conflict between two clients on the same transactions. And that's what we raised in advance of the arbitration. We were told to pick it up at cross-examination for purposes of going to the credibility or weight to be assigned to any opinion. And I asked the question, but we never quite got to an answer. Who Mr. Magisha purports to rely on to speak for the Zarnaks when representing to you, they have no interest in taking control of the company again, because it seems to be quite possible he's taking the position for one client that supports a different one without ever providing notice to the first.
Yes, I follow the point you're making, Mr. Cowley, and if you want to ask about the apparent qualification in paragraph 47, you're free to do so.
Thank you. If you could bring back up the first report of Mr. Magisha at paragraph 47. Apologize in advance for the awkwardness of the phrasing of this, because it's going to come out with an awkward negative. But Mr. Magisha, who do you purport to rely upon in informing the tribunal of the Zarnak's lack of wish to exercise authority over the company?
Mr. Coley, I've already answered your question to say I'm privy to the facts of this case on the basis of information provided to me in the documents, and that is on the basis of which I made this statement.
Please provide the name of the person upon whom you're relying in making that statement.
I have told you I am relying on documents that I was made privy to when I took on the assignment to provide this tribunal with an expert report.
Please identify the documents.
It's the memorial, it's the counter memorial, it's basically these judgments. That is what I rely on.
I asked a poor question. I cut it short. I shouldn't have. Please identify the document or documents that you point to and rely upon for the information about the Zarnak's lack of a wish to any longer exercise authority over the company. What do you point to as the source of that statement?
Look, I've provided you with the context, and that's it. I mean, I don't have any other answer for you.
In light of this effort to try to get a direct response, and based on the clear concern that a lawyer with presumably a lingering representation, a lingering obligation to either a current client or at least a former client for whom he had responsibility, or his firm had a responsibility in a transaction, knowing about material change by an action of the Supreme Court affecting that very transaction, knowing that he holds the information and perhaps his client does not know about it. I am very concerned about not being able to confirm, given the answers that we're permitted to hear, that the client who he's telling the tribunal has no interest in something which may be very material to the opinion that could ever be given by any lawyer as to Mr. Benzingi's role, regardless of how the confusion comes out. Who is protecting that client?
Mr. Cowley, this witness has said quite unequivocally that his understanding that the Zarnaks no longer wish to exercise authority over the company is derived from all the documents that are in front of us. Speaking for myself, it seems to me nothing could be clearer from the documents that the Zarnaks were not interested in the company, because the documents state that, and this has never been challenged, that they sold their interest in the company years and years ago. And if they had got on to this witness and said, well, we would like to get the company back, or if they got on to this witness and said, we just heard that it suggested we could get the company back, but we don't want it, then this witness would have told us that that was the basis of his statement. He hasn't said so. He said that it was based on the documents.
But that's the problem, Mr. President. I'm sorry I'm not being clear, but all of what you just said, I understand. If someone can confirm that the Zarnaks were informed, told about the ruling, and advised as to the related transactions, not just the ones discussed by the arbitrator, but the related transactions that may be impacted if that ruling is not dealt with, that may cause liability to Mr. Benzingi, because there's aspects of the transaction, and we raised it in our motion, as to the change in shareholding positions, which definitely would have some effect as to the share of the money that resulted from the transaction. So if Mr. Benzingi is benefited by the Zarnaks not being informed, not taking action to address it, not taking action to revive the effectiveness of the prior transaction, because of the silence of the lawyer who has an obligation to tell them, and that lawyer is now representing a party that benefits, along with Mr. Benzingi, from them not knowing and not taking it in action, that's the concern.
Mr. Cowley, hold on. You have had this expert statement for over 2 years. And if you had the concerns you've just expressed, you could have written and said, have you informed the Zarnaks about their not having an interest and so forth? You are effectively making accusations of professional misconduct right now, dealing with a conflict of interest with another former client that Mr. Mogishi had. And it is not before us, this kind of point. It is a point that needed to be resolved, if it arises really, differently and elsewhere. I speak for myself, of course, but I do not see how we can deal here with the question of an alleged non-disclosure in relation to which there is zero evidence and is not a problem for us. Our position is that we have an expert in front of us who ought to speak and does speak about what Rwandan law provides in relation to contracts and mining concessions and so forth. That is what we are looking at. And we are also looking at the arbitration award. We are not looking at Mr. Mogisha's former clients and whether he has fulfilled his obligations towards them. And I reiterate, I speak for myself.
And I will not belabor the point. I appreciate what you said. I just want to remind the tribunal, we did raise it in writing, in a motion. We felt it completely inappropriate to then take direct action with Mr. Mogisha, or otherwise take direct action to affect the record, having raised it. And the instruction we received as a result of our motion was to raise it in cross-examination. So while I appreciate your position, I just would like to remind you as to the reason why we thought we were following the instruction is exactly what you wanted us to do and how you wanted us to pursue it. I wouldn't have done it.
The objections you raised before was an objection of lack of independence on the basis that allegedly Mr. Mugisha had acted for NDR. And he made it very plain in evidence presented to this tribunal that he had acted not for NDR, but for the Xanax. That was the point then raised. What was not then raised is what you have produced this afternoon by way of allegation of non-disclosure to a former client.
I have nothing further to say. I'm not trying to antagonize the tribunal. I thought we raised it appropriately. And our point is not to accuse him of having done something wrong. I simply tried to raise the point that he can't serve in a position where he has two potentially competing obligations. He simply can't do it. I'm not suggesting he did something wrong. I'm suggesting he should not sit in a position where it's even possible, even if he does everything right. He shouldn't be opining on the effect of the Benzingi arbitration award at all. That was our point, nothing more. I've made it, and I respect whatever decision the tribunal issues on it. I have no further questions.
Yes, could you then please carry on with your cross-examination?
I think Mr. Cowley says he has no further questions, and I have no re-examination.
I just have one or two questions I'd like some help on. Could we have the contract back, please? That's C17. You said, Mr. Mugisha, that the question of whether there was a positive evaluation of the feasibility study was in the entire discretion of the minister. Is that right?
Yes, that's right.
Does it follow from that that no claim could be brought, no valid claim could be brought for breach of contract if the minister said, I'm not satisfied?
That is right.
Thank you. Now, could I just, it may well no longer arise, but I would like to just look with you a little further at this arbitration award. Could we have R009, please? And these are the memorandum and articles of association of NRD. Have you looked at this before?
Not lately.
No. Well, you'll see that it is in the form of an agreement between the initial shareholders, and we can see that the capital they are putting up in Article 6, the Xanax and Mr. Benzingi.
Yes, that's right.
As to the memorandum and articles of association.
Yeah.
And if you turn to Article 30, all disputes involving the company shall first be brought to the attention of the general meeting. And when the general meeting fails to resolve the matter, it shall be referred to the arbitrator agreed upon by the parties. Now, does Rwandan law help at all with deciding who the parties are, or is that simply a matter of interpretation of the agreement?
It's a matter of interpretation of the agreement. Yeah. But again, this is a matter that was presented to a court. Court did take a decision. And so it doesn't really matter what opinion anybody has on the rulings. Once it becomes a court decision, then it is what it is.
So who would the court decision bind?
It does bind every individual and public authority.
Sorry?
It does bind every individual and all public authorities.
So even if the shareholders were not party to the arbitration, it could divest them of their ownership in the company?
Yeah, I think the only, the challenge here is that for reasons which I do not, I'm not privy to, the court did find that all the actions for notification of all the parties involved were taken. And I don't know what happened for the proceedings to go on in the absence of all the parties concerned.
No. Can you understand how this arbitration agreement could give rise to an arbitration between one shareholder and the company?
It is very possible, yes.
Can you explain how?
Because once the company is incorporated, it also becomes an entity in itself. And the dispute resolution mechanism in the articles does apply to the company as well as to its shareholders.
So, can we take this any further? No. I don't think it's profitable to pursue this any further. I don't know whether either council wishes to ask any questions in relation to this.
Not for me.
No.
Other questions?
Very well. Can I thank you very much for your assistance. You're now free to go.
Thank you.
Housekeeping. Post-hearing briefs, you've agreed on the size of these. Have you agreed on the timing?
Yes, the timing's actually in one of the procedural orders. It's 6 weeks.
6 weeks.
It's been suggested to me that 6 weeks actually expires on a Wednesday, and it might be sensible to make it 6 weeks and 2 days, so it expires on the Friday.
That seems sensible, Mr. Cowley.
Agreed.
Mr. Kaplan, can we draw up an order to that effect?
Yes, indeed. I will confirm this in my daily email.
Good.
Additionally, would the parties like to confer now or later regarding transcript corrections, if any?
I think I'm not in a position to do so now, I must say.
Certainly not what they are, but you know.
Can I just say that it will be helpful to the tribunal to have the parties look through the transcripts, not only with regard to transcribing errors, but even slips of the tongue and so on, which we have noticed. And it will be important to have a correct record of everything. So we will definitely be grateful for that.
I suggest 3 weeks, and I do not have the next week available at all. So if 3 weeks would be preferable from our end.
Yes, that's fine from our end.
Very well. Transcript corrections within 3 weeks. Any other business?
It would be cost submissions if those flow from the date of post-hearing briefs, but also the dates can be confirmed at a later date. They can also be confirmed now. I'm just raising it since we're all together.
I wonder if that could be left for agreement between the parties. I'm sure there won't be.
I'm sure the parties can agree that. Yes, well, we'll leave that to you then. Right, well, just remains to thank all three of you and wish you a good evening.
Thank you very much, Mr. President.
Thank you.